Hi, everyone. Good evening. Carl Steinbeck here, covering day 6 of the Tennessee versus Blaise Taylor 2X murder trial, where he's accused of murdering his someone that he dated a few times, as well as the baby that she was carrying from him. So this is a case where the defense presented their case in chief today, and one thing you want to do is if you have a number of witnesses, you want to start out strong on your case in chief. Put some of the not so strong witnesses, or if they're all strong, it doesn't matter so much. But if they're not all equally across the board strong, then you want to put your strongest ones first and also last. So let's see some of the excerpts of today. And thank you for saying here in the comments where you're from. I'm always curious where people are from, and I see someone here from Seattle. But yeah, this case is very interesting. I think the defense has been very unorthodox in a number of ways they do things, and lack of preparation is one of the key things that I know, one of the key takeaways. So let's see here. So let me go ahead and switch this over to join in. Oops. All the way from Idaho to New York, DC, Sacramento. So welcome, everyone.
Anything before the jury?
Yes, Your Honor. At this time, the defense would move for a judgment of acquittal on a couple of grounds. One being that no prior attack would be able to hear or at least deliberate on the evidence that's been placed before the jury for the following reasons. One, in regards to the 225-23.
Oh, sorry.
Judgment of acquittal on a couple of grounds. One being that no prior attack would be able to hear or at least deliberate on the evidence that's been placed before the jury for the following reasons. One, in regards to the 225-23 blood that was considered by the medical examiner in determining the cause of death. In that regard, the witness testified that, and when I'm speaking of the witness, I'm speaking of Dr. Methune. Dr. Methune testified that there was no way that she, well, I shouldn't say that she considered and had to rely on the summaries of the individuals who performed the test for litigation package.
What are you arguing about? Chain of custody?
No, Your Honor, I'm the state, Smith v. Arizona, in regards, there was a surrogate witness that was placed on the stand. After her testimony, it was developed that she had to rely on the summaries of the individuals that actually performed the testing on that vial of blood for 225-23 and work order number 231-26889. That is the very vial of blood that the medical examiner relied on in determining the cause of death for Ms. Bennett. Given the fact that the expert who testified to the validity, the integrity, and the blood in terms of the cocaine being in the blood, that she was a surrogate witness, it should be excluded after her testimony when she stated that in the amount of time that she had to review all of the data, she had to rely on the underlying test and analysis. Additional to that, she actually testified, I did not look at each quality control. I was not able to actually check each batch. With her not being able to do that, it violated Mr. Taylor's right to confront all of his witnesses and therefore violated the confrontation clause. As a result of that, anything that was relied on by that surrogate witness should be excluded and should not be considered. Without the blood listed in work toxicology report number 231268889. There is nothing that the ME has testified to that she relied on in order to determine the cause of death for Ms. Bennett. In addition to that, there has not been one witness.
All right, she's just going through a dragnet, kitchen sink being thrown at the court here, trying to come up with every possible argument to try to get the judgment of acquittal. But she's going to lose. She knows that this situation here is not even worth going to the lectern. So she's just trying to do her job. You got to ask for it every time in a criminal case, but it's a loser because you'll hear some comments here by the judge to refute some of the points she makes. But you know, she's making this argument that hey, it's a surrogate type of testimony. This person didn't do every single test of the lab. That the toxicologists, the ME folks, whatever they want to say, that they weren't the ones actually doing the work. But they have a system in place. They have standards and credentials they have to meet to do lab toxicology work and all that kind of stuff. So welcome, Claire, from Yorkshire, England, all the way in England. So thanks for asking about my sister too. She's stabilized right now, but needs some future surgery stuff that's going to look pretty dicey. So anyway, just keep her in mind if you can. Appreciate any prayers. And so here we go. She's with us here tonight, I believe. So here we go. Continuing on here.
That has come and tied Mr. Taylor to any drug, any form of cocaine whatsoever. There has not been any evidence presented to this court that Mr. Taylor bought cocaine, researched cocaine, did anything of the sort during the
There have to be.
We believe that there has to be a causal connection.
So the sound isn't the greatest here, but the judge is saying, does there have to be, evidence that the defendant purchased the cocaine that killed the victim? No, that's not a requirement, as the judge said. But she's saying it is a requirement. No, circumstantial evidence can show that he was the one that spiked her drink or food, and she also we had the victim outcry saying that the accusation against him for spiking the drink and apparently having something in his pocket. So
between Mr. Taylor and the cocaine in order to determine that he
Just the proof based on who was in the apartment for the 3 minutes between the 911 call and the Miss Benning's call, wasn't it?
I would disagree in that it has not been established by any of the experts that the only period of time that Ms. Benning would have been required to take the cocaine, that it was only within that
There
3
plenty
minute
of testimony that it had been very quick.
However, they did not state that it would have been very quick after she took it, but we don't know when she took it, and we don't know who gave it to her. There hasn't been any evidence.
Be somebody in the apartment, or we Danny, or, that's a jury question.
It is the defense position that no causal connection has been made with.
the standard for this is you have to view all the evidence in a light most favorable to the prosecution, the non-movement. So here, everything has to be looked at as most credible, like everything that the prosecution witnesses said was credible. So assuming everything they said was credible, you also have the circumstantial element angle of it here. So this is going to be something that will be overruled or denied.
Between the cocaine and Mr. Taylor. As a result of that, in addition to the Smith v. Arizona issue, that there should be a judgment of acquittal, because without a cause of death, then there is no proof evidence that in fact Mr. Taylor could have caused the death of Ms. Benning. As a result of that, we move for a judgment of acquittal.
Okay. All right, does the state care to be heard?
Your Honor, Dr. Mithun was very thorough in explaining that she did her own analysis. She was not a substitute witness, just reading from someone else's report. She did her own analysis. She formed her own opinion. She wrote her own report. It is not even a comparison. Her explanation about that there's no connection to Mr. Taylor and the cocaine, and the state admits that there is substantial circumstantial evidence of he is the person who put the cocaine in Jade Benning's drink. Her own words were that she just didn't know what it was. Dr. Carney gave very explicit testimony about timing and that it wouldn't take long to feel the effects. She described dizziness as being something that would be possible, as well as the person might be able to walk, but not for very long after ingestion. And she said that a time frame of approximately 30 minutes until Jade Benning would be in full cardiac arrest, that was consistent with everything that she knew, and specifically consistent with the other autopsy she reviewed. That was the only one that had circumstances similar to Miss Benning's case. There is I would say proof beyond an absolute certainty that Mr. Taylor was the only one with Miss Benning in that apartment during that time frame. So the state would ask that their motion be denied.
Okay.
Yeah, that's the real key takeaway. He was with her as she was dying and having the heart attack, and and that was his MO, to try to make sure an abortion happens so he doesn't have to pay child support. So he strong arms people to get his way that way, and so she was adamant about not giving up the baby. She was going to keep it. She was all excited about it. So something was spiked in her food or drink. So, and he was there when it happens, and the only one there, I might add. So very strong circumstantial evidence.
All right, at this point, the court relies on the testimony that's been presented by the state. In light of that testimony, the court's discussed already the testimonial Smith v. Arizona issue. There's nothing the court's heard since that ruling that changes that. I mean, Dr. Mithun talked about each batch, but said that didn't affect her reliability of her testing. She looked at a number of them. I don't know if she was asked specifically how many, but and in terms of the causal connection, something happened to Miss Benning in that apartment. There is circumstantial or direct proof that Mr. Taylor was the only one there. So that's not my role to judge credibility. If they believe Miss Jackson's statements, then the cited utterance from Miss Benning tells us who it was. So
Yeah. So he just said what I said earlier, which is he cannot judge credibility. The credibility is already considered established for this state. So his hands are tied. Even if he thinks that anybody from the state's line or everybody's from the state's line, he has to take that in a light most favorable to the state's witnesses. So he's basically saying it doesn't matter what I think of their credibilities.
I'll overrule the motion for judgment of acquittal.
Overruling it.
Who is the defense first witness? James Smith. Is he here?
I would say this Letitia Quiones Hollins is very much a argumentative, unprepared attorney from what I'm seeing, and she's lost a lot of credibility, I'd say. I don't think the judge trusts what she represents, and he's had an extreme amount of patience to try to shepherd this out of control defense team and trying to give the defendant a fair trial in spite of the defense team having a lot of lack of preparation, lack of focus, lack of detail, lack of what looks like experience as well.
He is here, I understand. Really briefly, Your Honor, I think we need to test our computer system before we get the jury.
Oh, I thought that had already been done. The people were here.
I think we're here. I don't think we tested it yet. I just want to make sure we get it tested real quick.
Turn it on.
Is that your computer?
Yes,
What's on your computer?
it's a PowerPoint that's on
Well, your apps are down there.
on the section.
Your Honor, while they're sorting that out, the one other thing I think we're in a
I think
better,
we're marking. What is that?
I think we're in a better position to have a discussion with Your Honor about the jury instruction, Your Honor, reference 4210A. It doesn't have to be read this minute, but at some point when you're on jury, we can have that discussion.
Do you want it in the jury instructions or not?
At this point, I think our position is we don't necessarily want it in unless there were substantial revisions to it, which we can discuss, but I think as written, we do not want it.
Okay. Well, it wouldn't all come in if he has promoted an intent.
The other concern I will point out, Your Honor, is the language of that jury instruction uses the word crime.
That's why I asked you if you wanted. It could say crime or other wrongful acts.
Our position would be the word crime should be taken out entirely, because there's no proof.
I don't know. That's what I said. Whether the jury thinks discussing with someone else about facilitating or causing an abortion is a crime or not.
I think there's a specific case law that that's not.
So you want it in there if it says other wrongful acts?
I mean,
What word do you want in
the closest I think we would, I mean, I think that was our position on this entire
there?
form.
What do you want in there?
If Your Honor wanted to charge that, I think we would be comfortable with.
I don't want to charge anything. If it's up to you, I'm required by law to put it.
We don't want it.
Oh.
That's our,
What mark from that? What he was here.
So he's talking apparently about a jury instruction of other bad acts, such as sort of standard language to focus on uncharged misconduct. And I don't know why he's bringing that up now. Really, not the time to be bringing that up. You do that when you're working jury instructions.
We don't need this for the first witness, so.
Or it gets Detective Smith.
So the jury's waiting there. All this stuff should have been done well before the jury gets here. We'll see more of this here. Totally unclear. But also the prosecution, they should anticipate the defense not having their eyes on the target. All right, we've been going 18 minutes here, but I started 35 minutes in, so 35 plus 18. So, 15 minutes before the jury comes in. Bye.
Good morning to you, ladies and gentlemen. Jury, let the record reflect all of your work are here and present, and the defense wants to call Detective Smith. You'll raise your right hand and be sworn.
Do you swear the testimony you're about to give to you the truth, so help you God?
I do.
Good morning, Detective Smith.
Good morning.
Can you please state and spell your name correctly?
It's James Smith, JamesSmith.
And where are you currently employed?
The Metro National Police Department,
And how long have you been employed there?
nearly 13 years.
Did you ever have an occasion to get involved in this case involving Mr. Blaise Taylor?
I did.
Were you the first officer on the scene at the hospital, the first detective on the scene at the hospital?
I was first detective to respond.
Did you ever call Andrea Browning and give her permission to go into the house?
Initially, I did not recall that spoke, but yes, been talked about. Yeah,
And would you have given anybody permission to go into the house? Is that something you would have done?
the only time that would be done is because I was not doing the search warrant, and the officer I had released, the officer who initially was going to secure the scene or the apartment at that time. He had been released. The apartment at that time had been released, was no longer police custody to be frozen and such. So to give permission to anybody, it would have been after that fact that I can't say they can or cannot go in there at that time.
And just to be clear, do you have any documentations or recordings suggesting that you gave someone permission to go into the house?
I personally do not.
And would you have given permission for her or any friends to enter into the apartment?
If given permission, it would have just been family. I would have given the family.
And did you give family permission in this case to go into the apartment?
Based off the recollection that was given to me, it would have been either stepmom or mother, but Ms. Browning would have been the contact.
Would an email that you sent refresh or aid in your memory for your testimony here on today?
Yes.
Okay, so you're trying to say that family had permission, or are you trying to say that other people other than family didn't have permission? But how clear was this? Is this really a major point you're trying to bring up?
Have you had the opportunity to refresh your memory?
Yes.
After refreshing your memory, do you have any recollection of giving Mrs. Benny's stepmother or any family members permission to go into the house?
Like I said, initially when I sent this email, I had no recollection or memory of giving anybody permission.
And when did you send the email?
This email was sent yesterday, Sunday, June 28th, 2026, around, it would have been 4 p.m.
And do you stand by that recollection?
Not with the information that was given to me this morning.
What information was given to you this morning?
You provided me a transcript.
Yeah.
I still don't remember exactly giving the permission.
Yeah, I mean, they just really botched this. They should have been treated as a crime scene automatically, but they did not do so. And there's a lot of confusion. And the initial detective unit handles it unless it's turns into a death. And then the homicide investigation comes into play. So you got to hand it off to them. So it's just sort of like this hot potato kind of thing. And things are going to get lost in translation naturally in doing that battle handoff. So yeah, I agree with wildlife is rough. So yeah, so the police screw up though. Does that really affect the fact that how she died is from a massive overdose? No.
Like I said, there wasn't any documentation. I don't have a recording. The last recording I have was speaking or interviewing anybody was Mr. Taylor. But it was possible that since you gave me information to show this transcript that for Ms. Browning that I had spoken to her.
Okay. So is your testimony today that you called Ms. Browning and gave her permission to go into the house?
I would say it's possible, yes.
Based on what?
Based off the information that was given to me this morning.
And who gave you that information?
You did.
And the information that I gave you was what exactly?
Transcript from you say Ms. Andrea Browning testified that I called her.
Was it Ms. Browning or was it Ms. Burks?
I'm not sure. I recall you saying Ms. Browning.
It was Ms. Burks.
I'm not sure who Ms. Burks is.
Did you ever speak to a Ms. Burks?
I'm not sure who that is.
That is Mrs. Benning's mother.
I spoke to her on the phone initially at the hospital. Again, I don't recall speaking to her after.
And in that conversation with her at the hospital, do you recall giving her permission to go into the house?
No, not at the hospital.
Part of the thing also, think about it, the story from Blaise Taylor is that this is a allergic reaction. So they're flat-footed. They're just trusting him. Oh, it's a bad reaction, some kind of food or whatnot, anaphylactic shock or something like that. They're not thinking of a drug overdose. Not until they came back with cocaine in her system at such a massive amount did they realize that, hey, this is not an allergy here.
Any questions on this today?
With Sergeant Smith, correct?
Yes, sir.
Sergeant Smith, the other the uniformed officers had spoken to certain individuals, including Ms. Browning, before you did, correct?
Yes, sir.
All right. And if the timing reflects that your conversation with Ms. Browning was approximately 1:45 a.m., does that sound accurate?
Yes, sir.
And again, that would have been after Officer Fish discussed.
Yes, sir.
Interviewed her. And so at 1:45 a.m. and thereafter, you knew that
You know, they never had crime scene tape across there, and they never had any kind of lock over the door or anything like that. So, I mean, this is that's what happens. Stuff can get compromised. They can lose evidence that way. But there was some evidence that was preserved that comforted her. It just didn't happen to be the police initially.
there was not going to be a search warrant.
Yes, sir.
Right? And that there was not going to be any police presence at the apartment, correct?
Correct.
And so legally, whatever, was there any authority you had to tell them that they could not go into Jane Benning's apartment, secure it, and deal with it?
No, sir. Once it was released, I can't say who did not go in there.
Well, you said released.
Oh.
Has anyone ever actually been there to put
No.
up crime scene tape or stand at the door,
No, sir.
barring entrance?
No, sir.
And so whether you told her that 1:45 or thereabouts, or later in the call, you had absolutely every right to go there.
At the time, yes, sir.
That's all I.
Detective Smith, to be clear, yesterday in your email, you said you did not talk to anyone?
I said based off my memory and recollection.
So, how does this help the defense? By saying they didn't treat it as a crime scene and that the place was released. So, how's that helpful to the defense?
And I don't recall or recount talking to anyone about giving permission to enter the apartment.
And you are aware that your conversation with Ms. Browning, do you know if that was recorded or not?
The initial conversation with Ms. Browning at Vanderbilt Hospital is any conversation, again, the last conversation that's recorded in my interviews was Mr. Taylor.
And you would agree with me that nowhere in that recording with Ms. Browning did you give her permission to go into the house?
No, at Vanderbilt Hospital, there was no recording of me giving permission to anybody when I was at Vanderbilt.
And outs-
Okay.
I'm sorry.
You're good.
And outside of that recording, you don't have any documentation or recollection of ever giving someone permission to enter into the home?
I don't recall having documentation or
If it's released, then you don't have to give permission. Anybody that has access to her house, any friend or family, they can get in there. So I don't know what the point he's making. Do you guys understand it? LMR, you're saying we see it so much with how police operate. Surely they have a set standard procedure. I mean, a lot of it's triggered by, do they think a crime happened? If they don't think a crime happened, then they're not going to investigate properly. I mean, look how many times you've seen on true crime, something that's ruled a suicide turns out to be a murder, right? Because they just staged it properly good enough. And just like this one is staged properly enough to make them initially think, based on what he's feeding them, that this is an allergic reaction instead of a massive drug overdose. So that's sort of like what I've seen is that the first one making a report, usually the cops go with that and they don't ever critically examine it till later on, or never until maybe a defense counsel examines it. So I've seen that many times where first person that makes a complaint to the police, they're given like the golden immunity, and they could never possibly dream up of the fact that they're making something up to cover their tracks on some criminal conduct on their own part. So yeah, it's really, really surprising. But here they're just, as I say, they're flat-footed and not critical thinkers. But they got enough years experience that somebody up the chain of command say, hey, go secure that scene. But never happened that way. So at least not right away.
And like I said, Mr. Taylor was the last recorded interview I had.
And you do recall that a request was made for the scene to be secured?
I do.
Any other questions?
No, Your Honor.
All right, thank you.
Thank you.
Who's the next witness?
We will call Sergeant Lindsay Fish.
Do you swear the testimony you're about to give to be the truth, so help you God? I do.
All right, so now we're starting off with another cop. This second witness.
Can you please state and spell your name for the record?
Lindsay Fish, Lynsey, FIS.
You want to start out strong, and your first witness was a dud. I mean, there's really nothing there to really drive home any big points.
SH.
And how are you currently employed?
I'm a detective with Metro National Police Department
And how long have you been employed there?
since 2020.
And did you ever have an occasion to make the scene in an incident involving Ms. J. Benny at Vanderbilt Medical Center?
I did.
And would have been around February 25th of 2023?
Correct.
And in what capacity did you show up on the scene?
I was a patrol officer.
Were you wearing a body worn camera?
I was.
Was it activated?
It was.
The court officer is handing you a photo, and I want you to take a look at it. Do you recognize it?
Yes.
Does it purport to be a still image of your body worn camera from that night?
It is.
And is it a fair and accurate depiction of your body worn camera that you were wearing that night?
Yes.
Has it been altered in any way?
It doesn't appear to be.
Your Honor, at this time, I would ask that this be entered into evidence as a defense exhibit 3, I believe, or
Yeah, we're putting it in
55, I'm sorry. Permission to publish on?
Okay.
Can you describe what you see in the scene here?
This is the entrance to the ER of Vanderbilt Hospital.
So this is can you circle this right here? That pole, can you circle it on the screen, please? What is that?
It's a form of metal detector.
And if a guest were to come into the emergency room, would they have to go past that metal detector?
They do.
You see this person with that mask on right here?
Yes.
Can you circle that individual, please? Do you know what that individual is doing?
He is the security officer for Vanderbilt and was checking people in as they go.
And that's what he was doing that night.
Yes.
And to the best of your recollection, was this individual alone, or was there another security guard also present there?
There was other security there.
And to the best of your recollection, were they doing their job?
To the best of my recollection, yes.
Relevance? What's
Did
irrelevant?
you ever have an opportunity to speak with a Miss Brown that night?
Yes.
One second, I want to go right back to exhibit number 55. Can you tell me what, if anything, that security guard is wearing on the face?
The mask?
Is that a mask that they're wearing in this photo?
Yeah.
What about the individual that appears to be checking in? Is that individual also wearing a mask?
Yes.
And so was that a standard protocol and procedure that night that people entering into the hospital with had to wear masks?
Yes.
Now, I just want to try to orientate the jury to, when you say you were one of the first officers on the scene that day,
Correct.
would that mean that you would have come before any detectives would have arrived?
Yes.
Did you have the opportunity to speak with a Miss Andrea Brown?
I did.
And do you know who that is?
It was Miss Benning's stepmom.
And do you recall? And do you recall while speaking to her that Ms. Burks got on the phone?
I don't know who Miss Burke is.
Ms. Burks would be the mother of Mrs. Bennett.
Yes.
She did in fact get on the phone.
Yes.
And you were present for that.
I was.
And what, if anything, did you instruct them while you were in the presence of Mrs. Browning with Mrs. Burks on the phone?
I just informed them of what was going on and asked them if they had any questions.
And did they inquire about whether or not there was an investigation going on?
They did.
And what did you tell them?
I told them that there was an investigation going on.
Did you inform them that detectives will be coming out?
Yeah, I did.
Did you tell them that the house, the apartment should be frozen?
I did.
Did you tell them that in being frozen, no one in, no one out?
I did.
And you came before Detective Smith, correct?
Correct.
And again, when you gave those instructions, Ms. Browning was present
Yes.
and Ms. Burke was on the phone?
Yes.
No further questions.
Questions from the state?
Good morning, Officer Fish.
Good morning.
You were just asked if you recall telling them that the scene should be frozen, is that correct?
I do.
Okay. And if your body cam reflects you speaking to Ms. Browning around 12:37 a.m., is that accurate?
I don't know the exact time. When?
But it was prior to Sergeant Smith.
Yes.
And to your knowledge, Metro National Police Department was going to go out, conduct a search warrant, and freeze the scene.
I knew that that was a possibility.
Yeah.
And if Sergeant Smith's search warrant later got denied, and there's a possibility he told them they could go back to the apartment, would that make sense?
I wouldn't know that information.
Okay, would it make sense if there was no search warrant and no one was freezing the scene, Metro wasn't there?
So there's conflicting information, and it's middle of the night, and they're tired, and they just want to make sure things are being done properly. And so
Objection, call for speculation. The witness says she doesn't know that information.
Okay, rephrase your question.
Officer Fish, if Metro National Police Department has no legal basis for holding a scene, freezing a scene, if they're not conducting a search warrant, would there be any reason to tell the family that they could not go back in the apartment?
No.
Okay, those were my questions. Thank you.
Officer Fish, do you recall ever stating that you all had information that a possible crime had occurred?
I do.
And that's the information that you gave Ms. Brown, correct?
Yes. That the investigation was why the investigation was happening.
Fair enough. No further questions.
Any other questions?
Yes, sir.
Thank you. Please step down and be excused. Who's next?
It's called yes.
okay, still not starting out on a strong note here. Jumping ahead. Here we go. On with
Go ahead with your question.
Thank you. Could you please state your name for the record, please?
My name is Nia Gutierrez.
And Ms. Gutierrez, how are you employed?
I am a Tennessee licensed private investigator and a Texas licensed private investigator.
And how long have you been a licensed investigator?
In Texas for about a total of 7 years, and in Tennessee, I'm coming up on 1 year.
And did you recently move to Tennessee?
Yes, last year.
And what
Janie Lee, I hope I'm saying your name right. You're saying you sat through watching day 6 with your mouth open through it all. Is this unprecedented that defense has done these crazy maneuvers last minute, so unprepared, unprofessional? Well, you know what? They're allowed to get away with it because the prosecution wasn't anticipating this, and they didn't hold their feet to the fire and have pretrial conferences, motions in limine to make sure that they're getting the proper documentation, the notes of the experts, and getting stuff nailed down. So part of this was the prosecution not being aggressive enough. And then also the judge wasn't aggressive enough, I think, on getting the control of these attorneys to make sure stuff is being controlled properly. So it's sort of like if you don't have the defense started all, and then it sort of like a snowball effect. And so if you don't have the defense doing your job properly, you don't have the prosecutor holding their feet to the fire ahead of time, and the judge isn't alerted, and the judge should seize control over this as well. It's his docket. If stuff gets botched here and the jury's being held up and he's, getting these surprise objections and issues to resolve, and the jury's sitting there waiting to hear evidence, it just makes like the judge says, I'm looking like an idiot to the jury. I couldn't believe he said that. He was being honest, but I'm sure he felt like an idiot because they don't want to be missing their work, their time away from whatever else they do in their daily lives to be sitting through and watching these defense counsel try to throw up roadblocks in the last minute. So you're going to see unprepared lawyers all the time. It's just that, these are very expensive lawyers for this defendant. And so it's disappointing to see them not have better preparation. That's my take.
Company do you work for in terms of for investigations?
Out of Texas, I work for Willis and Associates, and out of Tennessee, it is Covert Results.
And how long has Covert Results been in business?
Since 2017 or 2018, I believe.
Did you have an opportunity to go out to the Ontario apartment where Ms. Benning lived?
Yes.
And when you went out to the apartment, did you have an occasion to view the apartment where Ms. Benning lived?
Yes, I did, on the exterior with the door closed.
Also, did you have an opportunity to view the marquee for the apartment?
Yes, I did.
I want to draw your attention. Do you have with you photographs?
I have something else, not the photographs with me.
Should have photographs.
Okay. I believe you should have that photograph in your packet there.
Yes.
Okay. Do you recognize that?
Yes.
Can you find that in your packet and can I get my copy back?
I'm sorry.
This lead defense attorney, Letitia, and it's her husband, apparently, Mr. Joyner. So they're from Houston. So they're coming all the way to Tennessee, getting a special permission to join a local attorney. It's the other guy on the far side of Mr. Taylor. So you need local counsel in order to do that. Every state has a requirement that if you have an out-of-state lawyer coming in, unless you got some disciplinary history that's bad on your record, you've been sanctioned by the court or held in contempt or something like that, as long as you don't have something like that, they're going to let you join in on a case in that state. But you better have local counsel who's admitted to that court. So they're sort of piggybacking off that guy at the end with a mustache.
Pictures not in my packet.
Okay, that's fine. Do you recognize that photo that you
Yes.
took?
Yes.
And what is that a photo of?
It is a picture of the marquee of the incident location demonstrating the physical address of the apartment complex.
Okay, I have that so that I can understand the jury. Is it?
His dad is a offensive line coach for the Texas A&M Aggies, a highly ranked football team, and so I'm sure that his parents are doing most of the funding of this defense team, and they're experts as well. So I'm sure it's well over $1 million when you combine all the costs here and also the travel costs.
The same fashion in the way that you photographed it?
Yes.
And are you the one who actually photographed this?
Yes, correct.
Your Honor, at this time I'd like to publish. Is that in fact the marquee for the Ontario apartments or condominiums?
Prohoc Vichy, it's spelled in Latin differently, but yeah, that's how you pronounce it.
Yes.
Have you had the opportunity to view any photographs from 2000?
Okay, just to take this question, my personal opinion would be to hire the best of the best in said town and bring in whomever else, start there. I think that's what I would recommend too. But they're going with this team here. They've represented, I know, a former pro football player for the Houston Rockets. The case sort of fell apart and some civil stuff. And they also represented who was that? Some basketball player that got into some trouble of some kind or whatever. And I think the case fell apart. They never went to trial on anything. So I don't see these guys having any notorious trial that they came out and did a great job on that made this family hire him. But in any event, they you can go look at their website and they say they're the most trusted attorneys in Houston. So I can't believe they have that kind of advertising, but go look at their website. You'll see what I'm saying.
2023 or February in regards to the Ontario.
Oh, I should add that this Letitia, she's listed on her website as like one of the top 500 trial lawyers in America, and also she has is on like the best lawyers nomination for best lawyers, and I don't know if it's the region or it's country or state or something like that. So yeah, she's marketing herself that way, but I think you can just sort of join those kind of things and have some friends of yours in the legal profession nominate you, and then you pay dues. And so I don't know there's any credibility to any of that kind of stuff.
Apartment complex.
Yes,
And is that marquee in the same fashion that it was in 2023?
yes.
Could you please read for us the address here at the bottom of the sign?
It is 1522 through 1550 Lebanon Pike.
You know, that's the thing right there. When I saw this sign this morning, I'm thinking, oh, well, you know what? You tell me he doesn't remember the Ontario apartments. Hey, I'm on the Ontario apartments at Lebanon. You know what? This is like a big complex, and I think the cops would all know where it's at. And so this is a key thing that the defense is actually bringing in. So I think, you know, if I'm the prosecutor, I'm like, hey, you know, I can argue this, and I never thought of it. But yeah, that nice moniker there. They're even establishing that this was there at the time of the murder. So
Thank you.
Lebanon Pike is one of the main streets. There in Nashville. I've been to Nashville quite a few times, and I remember that being one of the main strips there, one of the main arteries that is in the metro there.
Did you have an opportunity to go out and look to see apartment 107 where Ms. Benning was living at the time?
Yes,
And were you able to ascertain whether or not Ms. Benning's apartment had windows?
yes.
Where were
I mean, she's making all this flamboyant type questioning, like, were you able to ascertain that they had windows? And I don't know. It's just like, get to the point. This is dragging it out. And so what I think of what the defense is doing a lot with this case is they're thinking number of witnesses and length of questions, just sort of drag it out, and that gets you some mileage for them to forget about the prosecution's witnesses. Just try to string this trial along to such an extent that these witnesses are just it's like a mud fest, and you can't remember what the prosecution had for their evidence. So you get mind mush listening to this defense team.
her windows situated?
On the rear of the apartment.
If I may, Your Honor. Was there anything behind that apartment where the windows were located?
There is a trailer type business, it's a trailer service repair business at the rear of the apartment complex. It's rather large, and from my understanding, it's called TSR, and they repair trailers.
I want to first show you this photograph here. Do you recognize that?
Yes.
And what is that?
It is an angle from the rear of the apartment.
And are you the person who actually took this photo?
Yes.
And could you, for the jury, well, let me ask that it be admitted first, Your Honor.
Okay.
Could you, for the jury, please point out which window belonged to Ms. Benning's apartment?
It would have been, I'm not sure, Mark, I can mark on here, sorry. It would have been this one.
Okay. And I want to now show you another photo. You can clear the screen.
Oh, sorry.
Okay,
Got it.
there you go. I want to now show you this photograph. What is this?
This is a picture of the rear end driveway, you could say, of the apartment complex, coming in after you would come into the apartment complex and then turn to the left. It is a picture of the driveway alley behind the apartment.
And would Ms. Benning's apartment window be adjacent to that, I guess, would it be a pasture or field?
It would be, you could say parallel, yes.
Okay, parallel, thank you. And if you could just orient the jury where Ms. Benning's apartment window would be located.
I can point,
Yes.
it would be this way.
And did you take this photograph?
Yes.
At this time, we would offer.
We'll just make a collective, whatever you, get all of them you got.
If Ms. Benning was to have a camera in her window, where would that camera, if it was facing out, where would it focus on? Where would it be directed towards?
Depending on the range of scope of the camera, it would have captured the entire back alley drive here, or maybe just her back patio, or
I think what they're trying to do is show that this camera she had could have shown who's showing up to deliver drugs or something like that. It's what I think they wanted to argue, or will try to argue, but you'll see they get shut down here.
where a vehicle could be stationed back there, or all the way up into the trees. It's unsure.
Were there any other windows besides those windows that you saw in apartment 107 at the Ontario?
That is the only one that I recall.
I want to draw your attention now to another photo, if you can clear the screen. What is this?
This is an angle closer to the end of the parking where the truck repair service business is located, just below on the hill.
By the way, these photos were just taken in June of this year, just a few weeks ago.
That also behind Ms. Benning's apartment and the view that would be out the only window in her apartment?
Yes.
And what about this photo?
That is another angle showing the trailer service repair business.
Now,
Elmar, I don't want to help the defense. They could be having folks look at channels to see what people talk for social media insights and things they need to wrap up. So I'm not going to say anything to help the defense. As I've said, I think they're going down. I think they don't have a winner case here. I think they'll get a conviction. And so I'll just leave it at that.
did you have an opportunity at our request to do any research in regards to the son of Ms. Stephanie Franklin?
Yes, I did.
Did you determine a name for the son of Ms. Stephanie Franklin?
Yes, the name is Jordan Franklin.
And were you able to ascertain whether or not Mr. Jordan Franklin was in fact a police officer?
Your Honor, go check the relevance of this.
Okay, this is the person that said she talked to her cop's son in Arkansas, I think it was, and he said, yeah, you should be able to go in. And I mean,
Your Honor, there's been testimony that a police officer gave Ms. Franklin.
Right, you asked all about it. A police officer told her to do X, Y, Z.
Correct. And if I may, I would like to,
So what do you want to ask?
did you ascertain whether or not Ms. Franklin's son was actually a police officer?
Yes, so to answer the question,
so the defense can't get this question answered because the prosecution objection saying that's hearsay, out of court statement offered to prove the truth of matters heard, i.e., is this guy truly a cop? So there would have been a statement out of court saying whether he's a cop or not. So whatever. I think they're going to say something here that's a misrepresentation, perhaps.
Based upon hearsay.
Care to be heard.
Yes, it's not hearsay. She did the record search herself, Your Honor.
So it's not hearsay because she did the record search herself. So everything she finds for statements of others is not hearsay because it's considered research.
Well, I know that, but wouldn't the information be an out-of-court
I'm just being sarcastic here.
statement offered for the truth?
I don't believe that if you were doing, nobody told her anything. She researched to see whether or not the T.
I didn't tell her anything. Okay, like the hearsay is coming from me, then it's if it's not coming from me, then it's okay. Of course, you told her to investigate whether he's a cop or not. So I mean, it's like she's not being straight up with the judge here.
Existing
So
for
you want to litigate whether the gentleman was or wasn't a police officer?
I think that's very important for the jury to know, Your Honor.
I object. On the basis. It's hearsay.
I believe it goes on the effect of the listener.
Effect on the listener?
Absolutely.
Okay, it is hearsay. So I'll sustain the objection.
There it is, sustained. She's shut down.
Also, it goes to 609 impeachment, which allows you to impeach with hearsay.
Based on reliable information.
Correct. And I believe that the information that Ms. Gutierrez received.
Do you
is
have
reliable.
someone that you're calling from a police department saying he wasn't a police officer?
Yes, sir.
You do?
We have researched and looked
No, I'm
at.
taking, do you have a person from that department?
Ms. Gutierrez called that
I'll
department.
sustain the
directly.
objection.
And Your Honor, if I may, through this witness, introduce this judgment.
I certainly object to that.
Okay. The
It's
judgment about.
it's a certified copy in regards to
Okay.
this.
Have you looked at the certified copy?
I'm not sure which one,
Yes.
using the other one,
I gave it to you last, but I'll give you.
but we approach.
Okay.
Oh, this is right. If I hear this right, she has a certified copy of a conviction from that Chianti witness who's in dental school for thievery, some kind of theft conviction. If I heard it right. Yeah, I don't, LMR, I think he handles her well. I don't think he handles her that well because he's not calling her out on stuff. I mean, she's getting away with a lot of stuff. A judge would just rip into most attorneys like that. So she's sort of getting a free pass to do such a slipshod, shoddy way of presenting evidence. Is this thing rolling? Yep, okay. They shut off the sound. Yeah, she sounds very, talks down to the judge, talks the law like he's stupid, doesn't know Tennessee law. And that's just very much, I mean, you're going to get a judge that dislike you if you do that. But I think he's afraid to take her on the way he really should. She hardly ever says Your Honor or Judge, if you notice that. All right, let me jump ahead here.
Collectively. Any other questions?
No, Your Honor, not from this witness.
Okay, and get those, I think, maybe 5 photos that you asked her about.
Chianti was the friend of Miss Jackson.
Get those and we'll make them. 56 collectively. Okay, any other questions?
Not this witness at this time.
Okay. Any questions from the state?
I would request James.
Any statements you have from this particular witness?
No.
Okay.
May I see the exhibit,
The photos?
collective exhibit? Yes, sir.
Yeah, that's all right.
All right, so let's go. Come
I
on.
believe you said that you were employed by Covert Investigations. Did I get the name right?
Yes, and Wilson Associates.
He's just restating. He doesn't even ask her
And-
any questions, really. What's the point? I'm just going to skip this part.
Is that based in
There's no point.
Texas with an office here, or is it totally Texas?
I think if you have a witness on the other side that basically has no valuable information to convey that hurts your theory of the case, you just let it go. Just get on with it. So they pretty much had this witness crash and murder. She just entered some photographs of what it looked like outside the apartment, and that's it. That's it. So
The Willis,
The truck repair place is in the top of the picture, is that correct?
yes.
And now on this picture, could you circle what you say is Ms. Benning's apartment?
You want me to circle it on here?
Yes, please. In that general area, correct?
No, that would be the entrance to the breezeway to her apartment, but not on that corner.
Okay, well, would you circle in what
It-
part of that corner it is?
Probably right here towards the center, somewhere in that section.
A little bit further,
I don't know how this is relevant. Okay.
and this is part of exhibit 6 that, and obviously as we see,
I am a associate professor.
Okay, so
at
here,
SH.
so they have the PI as a third witness. The fourth one is this PhD type doctor from the Titans, the Tennessee Titans football team. She works there part time for them, so like the team psychologist. So this is a waste of time here as well. But I think what's trying to establish is that, hey, this lets the jury know, wow, look at, he works for the Titans. Keep that in mind. We even brought somebody that works for the Titans as well to say, hey, he's a good guy, and he was upset about this because he was, wanting to see things work out with his baby and the baby's mom.
Raise your right hand and be sworn.
Do you swear the testimony you're about to give to you the truth, so help you God?
Yes, I do.
They're just trying to load up every person that has a significant degree or title of doctor or expert, and it really doesn't amount to a whole lot of anything so far.
Can you please state and spell your name for the record?
Sheila Peters, SHEILA PETERS.
And how are you currently employed?
I am an associate professor at Fisk University, and I also operate a private practice.
Private practice.
Fisk, F-I-S-K University is what she said.
And what?
Clinical psychology.
Did you have to go through or undergo any schooling for that?
Yes.
What's
we
the,
are objective. They're not calling her as an expert.
this is background information on if I may.
Okay, go ahead.
Did you have to undergo any schooling for that?
Yes.
What kind?
Undergraduate degree as well as a master's and a doctorate.
From where?
Undergraduate degrees from University of North Carolina, Chapel Hill, my master's and my PhD from Vanderbilt University.
Dr. Peters, have you ever been employed with the Tennessee Titans?
Yes.
In what capacity?
As the team clinician.
And in that role, what were you expected to do?
In that role, I was expected to provide support and assessment for players, coaches, and the entire organization.
And when you say support, what, if any, difference is there between support and clinical work?
My role was to help anyone that was experiencing any kind of distress and determine what their best treatment would be.
Did you ever come to know Mr. Blaise Taylor?
Yes.
How?
During the playing season, on average, I would attend one practice a week, and I would see him as I would see other individuals coming out to practice.
And in those general interactions, what was, if any, your impression of him?
No, I object to that.
Impression.
We're not having
They were co-workers, Your Honor. I'm just asking her what was their impression, her impression of Mr. Taylor.
with a time frame.
I'll sustain
Your impressions of the defendant, I mean, what's okay?
the objection.
I think if you want to establish the fact that somebody was acting like they were upset because they lost a child and a girlfriend or something like that I think is fine. The demeanor is relevant, but they don't really know how to ask that here of this witness. And she was so limited in having interaction with them. Was it really the best you could do for the Titans? Somebody from the Titans?
And did you ever interact with Mr. Taylor in 2022?
Just cordial hello. Mhm.
And Did you ever interact with him in 2023?
Yes,
And what was your interaction with him?
I was asked by the GM.
All right, objection,
Okay,
hearsay, and this is in a professional capacity.
If I may, Your Honor.
what is your question?
My question is, did you interact with him at all in
And your answer is
2023?
yes or no?
Yes.
Okay, she did.
And what time frame did you interact with him?
It was in March,
Was it once or more than once?
twice.
Do you recall any dates?
Yes,
What dates would that be?
March the 3rd and March the 8th.
And when you interacted with him, what is any impression that you have of him?
And again, Your Honor, I object.
Okay, to get an impression, she'd have to be declared an expert in what?
I'll rephrase my question.
Okay.
What, if anything, did you think of his demeanor when you interacted with him?
Your Honor, I object to what she thought about it, because that would be a
Okay,
clinical
she
assessment.
described his demeanor. What was that?
He was concerned about the situation.
That would
Yeah, the demeanor. So there you go.
get into hearsay.
Yes, sir.
So,
She just described his demeanor as concern, Your Honor.
okay, concern. All right, then what's your next question?
And the second time you interacted with him, when would that have been?
She said that already.
What
March
did-
8th.
March 8th. And what was his demeanor like when you interacted with him on March 8th?
On March 8th, he was troubled because Ms. Benning.
Yeah, see, you can't get into things he said, and you relied on those to come to that opinion.
Your Honor, I thought she testified that he was troubled, not that he said anything.
If she was about to say that, because of something,
Do you know why he was troubled?
And Your Honor, objection.
that would be based on hearsay from your client. She said
So the judge is explaining how to get evidence in, and they're just stumbling and fumbling through this here. They don't understand it.
he was troubled. So what's your next question?
And
What's your next question? I think if you're an attorney in his shoes and you're just getting slammed with objections and the judge isn't giving you a bailout, then you're afraid to ask your next question probably.
were you there to support him?
Yes,
And how did you do that?
Your Honor, I object to the relevance of her support.
Okay, I'm there to support him. Yep. So he's trying to he should be trying to bring out his demeanor more. When did she see him? What did you observe of him? You know, those kind of questions, instead of, he just doesn't know how to ask the right questions.
Your Honor, that
Did you counsel him? That's a yes or no.
yes,
Okay, what's your next question?
Next question.
and as a result of your interaction with him on March 8th, what, if anything, that resulted from that interaction?
Your Honor, I object to that.
Let the lawyer step up.
Mr. Senior prosecutor there, he's taking this guy to school here, and the judge is letting him know this isn't working. Whatever you're trying to do here, Mr. Joyner, is not working. So it's I mean, this is like so cringy. As a defense lawyer, seeing this is how you start out your day. You're supposed to start out strong in the morning, and you're just stumbling and fumbling and really looking foolish. I get what they're trying to do. They just don't know how to do it on this witness.
Any other questions?
And you know, the thing is about what they're trying to show about the video and stuff like that. You could have asked the witness, okay, based on where the camera was, how did this tie into people coming and going? Could the angle of the camera be taking video of people coming and going, parking at a certain spot where her interior security camera could have seen if a vehicle's coming up to make a distribution or something like that? But they just sort of they get busted in the jaw, and they just sort of get stunned and get reeling backwards, and they try to come back for more, and they're getting punched around here. So it's not looking good for the defense.
Dr. Peters, do you know if Mr. Taylor remained with the Titans after March 8th?
I don't know.
Do you know where did he go, if anywhere?
Sometime thereafter, he went home.
Do you believe that was a good decision?
Well, Your Honor, whether she believes.
Okay, I'll sustain the objection.
When you encountered Mr. Taylor on March 8th, was there anything out of the ordinary with him?
It's been asked and answered.
How would you know anything's out of the ordinary unless it comes from hearsay?
Well, based off of the impression that she would have gotten observing him and interacting with him, what his demeanor may have been.
She's described that as trouble.
Yeah, but so the judge is sort of getting frustrated. So he should be able to say more, get more out of his witness than just say he looked troubled. So anyway, it's so that's what happens. You sit there and stumble through this and you don't ask the right questions. The judge just doesn't trust you anymore, that you know what you're doing. He's just shutting it down. Okay, you got to say that he was troubled. Okay, why wouldn't he be troubled? How's that relevant to really show something that's critical to help the defense? So
She did, but not in relation to what was actually happened when he left. So I think it's a little nuanced there, Your Honor.
Okay, well, I'll sustain the objection.
During your time at the Titans, did you ever have any personal problem with Mr. Taylor?
No.
No further questions, Your Honor.
okay, how's that
Any
relevant?
questions from Mr. Taylor?
Okay, I didn't have any problems with him. Okay, did he come to you for help and how to psychologically deal with having lost his baby and the mother? You know, maybe that's something the prosecution could ask, but
No, Your Honor.
Thank you, Mr. Smith. Step down. Do the next witness.
At this time, Your Honor, the defense will call Dr. Melissa Jerry.
Jerry.
sort of like, there's also something I call rope-a-dope, just like Muhammad Ali. There's sort of like they're trying to get all this evidence up against the ropes and just sort of like pounding away and hoping they score some points. Cause confusion. That's one of the defense angles as well, is just cause confusion. If you look confused, you bring confusing witnesses, and then it just turns into this big mind mush, and you can get the eye off the ball of the prosecution's surgical strikes against your client.
Your Honor, at this time, pursuant to previous discussions, statement request carry out. First, we have no report.
All right, ladies and gentlemen, the jury appeals step down the hallway, just briefly.
Poor jury. They've had an unforgettable morning.
And what is it? Hang on a second, man. What is this witness being offered for?
This witness is being offered in regards to the NMS reports. To the NMS reports that were tendered to the defense in regards to the blood and urine of Ms. Bain. And the testing of that blood and urine that went to the cause of death in this particular
And
case.
you're wanting her declared an expert in what field?
And laboratory testing of toxicology.
Is she a toxicologist?
She is.
Okay. And the state's objection is what?
If we have no report, we have her CV, but no report to know what the parameters of her.
Do you have a report from her?
She didn't give a report. She looked at the evidence.
Okay, now get this. You're calling an expert witness. They've done no report. You got nothing to hand over to the prosecution. I mean, think about it. When we had Mr. Blue Man, and then you had ARCA, the phenomenal experts that blew apart the state's case in the Karen Reed case. And here you got no reports, nothing of any kind to present to show this on any big screen or anything. There's no report whatsoever. So then they're asked about notes. Surely this expert has taken some notes when they're reviewing what they said, up to 13 forensic reports are generated in this case. I don't know why there'd be so many, but and watch what the defense attorney does here.
Do you have any report? No, I'm asking you, do you have any information from her that would be considered a statement?
I don't, Your Honor. I've asked
I'm
her.
not talking about you, I'm talking about your firm, your counsel.
No, I am the firm counsel. We don't have anything. I've met with her on several occasions. I have my work product, but I don't have any notes from her.
So she's never emailed you or anything like that?
It was all over the phone. She didn't want to get in writing where the notes could be advanced ahead of time and given to the other side where they could develop points to attack her. But what the prosecution does here is they have their expert listening to her over the phone. The judge helps coordinate that. So they're able to then have this expert advise the prosecution what questions to ask in cross-examination.
But it wasn't a report.
Her notes?
I don't have notes from her. She may have emailed me in regards to what time is the Zoom call, or are we?
She didn't have a report.
No. she
So
didn't.
what do you want me to do?
Welcome.
I think we would hear her testimony out of the presence of the jury for the court to determine whether it will materially assist the jury and basically the McDaniel hearing.
So you're,
Okay, the operative word is substantially assist. You use the word materially assist, which is what the requirement is for an expert to bring on an expert under the rules of evidence. And so what's going on here, though, is like this should have been done well beforehand, before the jury got there. If you need to come in 2 hours early, come in a different day. Granted, they had trial all Saturday, but you tell the jury to come back in later. So this is flat-footed advocacy on the part of the prosecution here. At least they're finally doing something, but you just don't disrespect the jury's time like this. And the judge should have anticipated this as well, that it's sort of going to be a hot mess by these litigants.
thinking this particular witness isn't qualified as a toxicologist.
No, it's the substance of what she testified about that we have no knowledge. She just now says about NMS. Well, if we'd had a report, we might know whether to have.
Some people don't.
So apparently all they got was her CV, her resume, and nothing else. They don't know what this expert's going to say. So I just wouldn't believe that there's not notes or something you get ahead of time. And so what the judge does is talk about the rule, and the rule talks about any report or anything generated by the expert. And that would, in a catch-all, include notes.
Do reports for.
But then you have the defense attorney saying, well, I didn't get any notes. Well, okay, well, you're supposed to ask for them. So you don't even ask for them. And then, the judge could very easily say, you know what? You don't have any notes even to give over at this time. I'm going to strike this witness from testifying. But then you hurt the defendant. Then you got maybe ineffective assistance of counsel. So, and rather than going through all that, the judge okay, we'll let it happen. But then it wastes all this time. And anyway, it's just a big goat rodeo from this point on. Really, yeah, it is sort of a waste of time to see a lot of this stuff. It's embarrassing. It's embarrassing to see it.
Tactical reasons.
Yes. And it appears, since the witness has a notebook with her, that would be some, if nothing else, jigs material that we would.
What is all that?
Your Honor, it is my brief notes to prepare for testimony today and the NMS reports that were provided.
Okay.
Yeah, I mean, if you don't have a lot of good stuff, you probably told them not to provide a report. I agree with that. I was so happy saying Letitia probably told witnesses not to provide a report. Yeah, none of them create a report, or create a summary of witnesses or something like that.
Do they have a right to look at that?
Sure.
How long do you need to do that? See, the jury's back there thinking, I won't say what they're thinking.
Your Honor, the last trial, when we had this come up, let me recall that the court said witnesses would be excluded if they did not prepare a report. And here we are now without a report.
I don't know if I said that.
As well as counsel saying that they were only intending to call Eric Devlin.
Well, I don't know who that is. I mean, this person is listed on the witness list.
We have provided the state,
Plea deal.
we have provided the state a full list of all of our experts.
Okay, under the rules, though, you're not required to have a report. Okay, just to make that clear, the defense is not required to have a report of a witness, but anything they do generate should be turned over to the other side, the prosecution here.
And a brief summary of what they are to testify about. The rules and the statute does not require that every expert draft a report. Any notes that Dr. DeGarry may have, I don't have those notes. And they're more than willing to look at whatever notes that she's made in order to assist herself in this testimony in the same manner Dr. Lafleur had to give me notes when she turned over almost 10 pages of notes to me.
Do you have all of your notes pulled out?
They're right here, sir.
Do you want to look at those? The state want to look at those before she testifies?
Yes, sir.
Okay. Run.
Okay, you know what? Like I say, it starts with the defense. They should be asking for the notes. The prosecution should be asking for notes before the jury gets there, well before, teed this up ahead of time. And the judge should have anticipated this as well. So it's looking pretty much a hot mess here.
Copy for those, Mr. Evans. And of Dr. Bartolome, Dr. Larkin, and Dr. Lindsay. How many of those do you plan on calling?
Yeah, you can find some channels that are very anti-prosecution. So I'm just calling it like it is, folks. I'm not going to sit there and pump you up full of different agendas. Okay, I'm just telling it like it is. And if I thought the prosecution wasn't proving their case, but I thought the guy was guilty anyway, then I would say that as well. But right now, I think they're proving their case, and the defense is looking like they don't have a lot to counter.
Do they have notes?
I can find out.
Do they have reports?
They do not have reports. All of our experts, Your Honor, reviewed all of the toxicology reports in this case. There were almost 13 toxicology reports in this case that needed to be interpreted. There were litigation packets that went along with those toxicology reports that were out of the purview of counsel's knowledge. We're not scientists. So we had to actually confer with experts in order to understand the science in this case.
Sure.
And so we hired experts to assist us to do that.
Can you have someone get from those other 3 doctors their notes that they would be using to testify?
I certainly can.
And get those to the state?
I certainly can.
All right.
I've not seen that before. I've not seen our expert. Well, actually, I've used an expert one time that didn't have a report, but it was something very, very minute point, and but it was a critical point. So, you know, somebody I wasn't even that I didn't even hire, they were willing to do it for free. So, anyway,
Go ahead and do that. How long is the state meeting?
We were very much under the impression, based off of Your Honor's prior rulings in the hearings, that if they did not provide us reports, their experts would not be allowed to testify. We would have had Dr. Mithun stay so that she could be in the courtroom and listen to this, so that we could recall her as a witness. We are without our experts, which is exactly what we said.
all right, she's sounding whiny here. I mean, you need to have this coordinated. Professionalism among prosecution defense should be such that you want each other witnesses to be able to hear what the others are saying. And so just have some professional courtesy for that. So, yeah, I guess prosecution, you don't hold their feet to the fire, and, you know, they're going to get away with this and waste all this time.
We ask Your Honor to exclude them if
I
they
don't
do
think I
not
can
provide a
exclude them
report.
when they don't provide a report.
Excluded for not having a report. Yeah, the notes, are they really a report or not? I mean, then you're looking at a possible reversal on appeal, because if you get a conviction and defense didn't give proper notice, then are they ineffective? So, I mean, as a prosecutor, think about what you're asking for here. You know, the judge doesn't want to blow this case, so he's gonna help carry the water for the defense.
The rule talk about turning over a report discovery if there is one.
You know, the state didn't give us notes of all of their experts.
They got the
I don't know.
litigation packet, that is their
You
note.
said you had 1,300 pages.
We asked for that litigation packet and paid for it ourselves. The state did not provide it to us. We provided it to them.
Do you want time to get Dr. Carney or anyone else up here?
Judge, our toxicologist is in Pennsylvania.
We never said we
I
wanted.
didn't ask you to say anything. So what do you want me to do? Declare a mistrial? Delay it till next Monday?
Would Your Honor allow us to contact Dr. Mithun and see if she is available to watch it by video, so we can at least confer with her after this witness testifies, if she was present today, she would be allowed in the courtroom.
Sure,
Did you know which order they're bringing witnesses? You didn't get that worked out ahead of time. And if the defense not going to cooperate with you, know what time window you're looking at it so you can have your own expert prepared to listen in or be there and listen in or listen in via phone.
you can go on, as I'm understanding it, live streaming and watch it.
May I step out to get in touch with her to see if she's available to do that?
Or get those other notes. We'll be in a 15-minute recess.
Okay, so they're trying to get all that coordination done. Let's jump ahead here. So that's still mid-morning, and we have this break, all because people don't know how to keep the trial moving.
Do you want to be heard under qualifications and all, and I can do that?
Not as attorney.
Okay. And then if Dr. Minton is to be recalled,
I haven't heard anything.
what are you talking about?
I said, if she is, so that we can get ahead of it, we would like notes and emails as well, please.
Notes, email about what?
Her testimony and her notes that
She would be, as you said, offered as rebuttal.
and I would.
Raise your right hand, we'll just bring the jury down.
We just got handed, are these more notes for her?
Shut the door there. Did you give this earlier when we were in here, all of your notes?
That I had with me? Yes.
I have 4 pages that she handed us.
What is all of this?
I just got handed this.
Oh,
Print what you asked us to print.
you just got it because you didn't demand it earlier. Yeah, look at me, Judge. I'm having such a rough time here. I'm not being treated fairly. I feel sorry for myself, don't you?
For this witness?
Yes,
I thought she provided it.
you wanted emails, so I.
No, I didn't want emails.
You
I
asked,
asked her for notes.
she gave her notes,
What are these?
my emails.
These
I
are
didn't
not,
ask for emails.
Kitty, I've been making a lot of comments. So if you want to go back and rewatch, they've been just pretty horrendous here today.
not emails. I just got a whole stack of notes.
What is all this stuff?
That was you had asked earlier, I had sent her work product of what I was doing as I was reviewing the data, and that's what that is. That's what I sent to her a long time ago prior to preparing for testimony. This was my analysis of going through the data.
So she did give you notes.
Sounds like a
Let me see what you have, I don't know what you have.
It's not,
That's what you emailed them, and somebody printed these out for me.
it's not a report. There's not an opinion.
Remember, the state would need for
This is
objection to
this
this
is-
witness.
This is the exact same thing that is a snip of the litigation act. It's all it is. And
Okay?
then other
You
people-
determine whether most of that is from your witness's litigation package?
There's only, I think, the last 3 pages of this. This is
And then
all
what's the other
notes.
stuff?
May I explain to her what she's looking at?
I'm asking counsel.
If you look, all of this are snippets of the litigation text.
Is all of this snippets from the litigation package?
All of it is derived from the litigation.
And then
What do
there
you
are
mean derived
notes on
from?
top of it.
It's notes on top of it of what I was
From
seeing
who?
from me as I was.
Why didn't you
looking.
give us that earlier?
I didn't have it, sir. I don't have
See,
it.
this is what high the ball is off. You know, I got a jury back here, I guess I'll direct myself to you, that's thinking I'm an idiot because of this trial. The procedure, the logistics, and they're back there wondering what in the heck we're doing. That's why, you know, the intent of Rule 16 is not hide things.
I'm getting the notes from the same number that they gave
Why
to
did they
me.
give
with
them?
Dr.
I'm not worried about how they
Miller.
gave them to you. I'm dealing with how you gave them to them.
Well,
Do you think, Mr. Brand, Rule 16 doesn't include providing these notes pre-trial?
No, he did, and so.
No, he didn't. Y'all didn't. I'm asking him, do you think Rule 6?
So Rule 16 has to do with expert witnesses and all the requirements that we talked about, turning over notes and all that kind of stuff well in advance, notifying somebody their testimony and things of that nature. So the judge right now here is saying, yeah, the note should qualify for that. But you know what? Everybody's asleep at the switch. Prosecution and defense.
Would include, when it says copy, photographs, documents, reports, and provide the other side, if you've requested discovery. Did that include this stuff?
No, Your Honor,
How so?
because I think that's probably James material, under 26.2.
But they're reports from what you're proposing to be an expert.
I don't think that's a report. I think it's her working notes as she's reviewing the material, which could be James material, but is not a Rule 16 report.
See, that's the problem with efficiency.
Jenks material is usually something in federal court where if a statement of witness in court, if there's a previous written statement of a witness in court, you have to turn over after they testify in direct. You have to then turn over the written statement to the defense. And if they have a reciprocal rules of discovery, same thing has to be for the defense to turn over the prosecution. So that's what they're talking about when they say the Jenks material. But a good prosecution officer, they just turn it over well in advance of trial when they turn over their entire case file. So there's not any issues of lack of preparation or confusion.
Which I hate inefficiency.
I appreciate it.
Yeah, I'm sure he's just pulling his hair out right now because he's tired of dealing with these attorneys, especially defense.
So, do you need additional time now?
Yes, I would like for my expert to be able to have this. I just got handed it.
Can you email that to your expert?
You should have anticipated them sandbagging it till last minute, prosecutor.
Completely disorganized. Judge, I submit that what she has provided is a report that she provided to the defense, and she just said it was a while ago, and the defense did not provide it. We filed a motion to exclude and asked Your Honor to exclude any witnesses that had not provided us with a report pre-trial.
They're saying that's not a report.
Yeah, it's okay. They're playing games, and you're flat-footed, prosecutor. So,
I mean, do we need to have a jury out to determine if it is? If it is a report, is Your Honor going to exclude it?
Sure.
Then I would ask the witness, there be a proffer to the court for the court to make a determination.
Inspect, copy or photograph books, papers, documents, photographs, tangible objects, or copies or portions thereof, if the item is in the defendant's custody and intended to be introduced as evidence in their case in chief.
that sounds like that would include notes. Any judge would say that includes notes. Anything that they produced is something you got to turn over. And you know what? They didn't do it, so they technically should be stricken from testifying. But then, like I say, you have these other second, third order effects where you got an issue on appeal about denial of an expert, incompetence of the defense. So
This is not being introduced in our case in chief.
That makes no sense.
Well, it's not being introduced for our case in chief.
So you want to orally ask her all about it and then just.
I'm doing the same matter that General Norman did.
I'm not dealing with that. I'm dealing with, have you complied with Rule 16?
Yes, I have.
yeah, okay, yes, she has. I don't think she has. The judge doesn't think you have either, but he's letting her off. He should be scolding her and saying, you know what, I really shouldn't be allowing any of this testimony to come in, but for the sake of your client, I'm going to allow it to come in. All right. But he's going light on her.
So you're not going to ask this witness to introduce anything?
No, I'm not.
Yeah, they could have.
So what do you want, General Norman?
Well, honestly, I guess maybe my paperwork to go copy it and send it to our expert.
I thought you got an email with that in it.
I haven't even had a chance to look at it, but what the little I looked at, it looks like she typed up a report.
It's not a
to them.
report.
Where is that?
Okay. We know whether she typed up a report or not. The judge is going to allow her to testify. He's not going to let the defendant get railroaded because the defense attorneys are not able to do their job properly.
Where's the copy I gave you?
Here it is.
What page in that are you thinking is a report?
There's one that has like 7 or 8 pages and a couple of pages of litigation packet in the back.
Well, I'm not worried about the litigation packet.
I'm not either, it's everything that precedes it.
It would look like, I don't know, what, page 47, 48, what are all these notations for the litigation packet?
Yes.
Page 50, 51, so that's just a summary of what she's looking at. 69, 75,
Okay.
81.
I'm not going to go through this point. Let's go. Here's the defense expert.
And how are you employed?
I am currently an independent contractor for forensics toxicology and science.
And where are you in terms of company that you work for? Who do you work for?
I currently work for a company that I own. It's MG Forensic Consulting.
And how long have you been a toxicologist?
I started doing toxicology in 2014.
And where did you go to school?
I received my Bachelor of Science at the University of North Texas, and I also received an Industrial Master's from the University of North Texas in Chemistry. An Industrial Master's is different than a regular Master's because I did not have to do a thesis. I had to be working in the field and had to write my paper in regards to what I was finding and doing the lab work in the field. And then in 2023, I graduated from Oklahoma State University with a Doctor of Forensic Sciences with an emphasis in toxicology. It is not a PhD, it's a professional doctorate. The difference between a PhD and my doctorate is I didn't have to write a dissertation. I had to be employed in the laboratory, and all of my papers were based on data that I produced while working in a laboratory.
Okay, so I'm going to go and jump to the cross-examination.
Okay, you said read it to the record.
I wasn't sure how the court did it, so it doesn't matter.
Do you have a
Sorry, I didn't have a timestamp on this. Bear with me a second. She was up there on the witness stand a while. I remember that. Stand by.
No, they're already part of the list. I gave it to Ms. Pendleton.
Yeah, but there was one for the hospital, but I didn't get that.
So they had the prosecution witness listening on the phone. The judge coordinated that, made sure that the top toxicology expert for the government was able to listen in.
Sorry, how do you pronounce your name?
Dr. Gier.
Dr. Gier. Okay, Dr. Gier, do you actually do any lab assessments?
What do you mean by lab assessments?
Do you go to other labs and do you perform an assessment of the lab?
When I worked at the laboratory, I did the internal auditing of our own laboratory. So yes, I did do assessments. I don't do external assessments.
Okay, so you are not trained in assessing and reviewing another laboratory's
Yeah, the jury's present now.
standards and processes?
If you're asking if I am been through the ANAB assessor training, I have not.
You have not been through the ANAB assessor training.
I have not.
But you are here testifying about the processes of NMS labs.
I'm testifying to their data, yes.
Okay, but you are not trained as an ANAB lab assessor, correct?
Correct.
Okay, and did you know that Dr. Mifflin is trained as an ANAB lab assessor?
Yeah, that's great.
So she actually goes to other labs outside of her own lab and she audits them for their standards and accreditation. And she has been trained in that. Did you know that?
No, I didn't.
You referenced that you reviewed the first hospital blood and you were talking about some seals. In your notes that defense counsel provided just before you testified, your notes under the report from Forensic Medical 2312-6889, You list what samples were submitted, and it says blood, in parentheses, jade, liver, in parentheses, jade, liver, in parentheses, baby. These are your notes.
Can I see that? 'Cause I don't have a copy of that.
Sure.
Okay, and what was your question?
Your outline of notes, you list blood, in parentheses, jade, liver, in parentheses, jade, liver, in parentheses, baby, correct?
Yes.
Okay, so those are your notes reviewing these laboratory results, correct?
Yes.
Thank you. So apparently you are not aware that Jade's liver tissue was not submitted for testing, correct?
No, when I made that you're referring to, that was my work product. That was just stuff as I was looking at it, and I didn't know if that was Jade's or if it was the baby's, because there's two listings for the liver. There's the homogenate and then there's the liver. So I didn't know what was what at the time when I made that list. I had since got clarification, and that is an older work product that I had. So that was not updated.
I don't see them intentionally trying to be ineffective, so I just don't see that happening.
Prior to my testimony for today.
You didn't update it when it was clear that it was only fetal tissue that was submitted. It was documented in multiple different places, but you didn't notice that. Going on to your comforter testimony, which again, you are not trained in any type of assessment for another lab, but would you at least agree with Dr. Mithun that reviewing data from your own lab is a different process than reviewing data from an outside lab? Would
Yes,
you
it
agree
can
with
be.
that? It doesn't take as much time because she is familiar with all of the NMS processes. Do you agree with her on that?
That could be true, yes.
Okay. And Ms. Hollins took all this paperwork and stacked it up. The litigation packet is
One of the things that she said at the end of her direct was like that if she could do the certification in 53 minutes, she goes only if she was speed reading. In other words, there's no way this is a legitimately derived toxicology report. So keep that in mind as this continues.
in no way, shape, or form required or relevant to do a specific case review. Don't you agree?
No, it should be.
Now, you were doing a case review to assist the defense with litigation. Dr. Mithun was looking at testing of a very specific case. She was doing a case review. You don't agree that those are two completely different things?
I think both reviews should be equally the same because as maybe I am reviewing for the defense, she's reviewing for the prosecution, and it should look at the entire batch and all of the quality controls and all of the standards and all of the paperwork to make sure that there is nothing that was missed within the other people's reviews.
Dr. Gear, you are very aware that what Dr. Mithun did was a separate forensic analysis. She wasn't doing it for the state. The state made a request that it be done.
All right, so this is a good tone of disbelief the prosecution has. So glad they're stepping up.
It's completely different than what you were doing for defense counsel.
We're both reviewing the litigation and reviewing the data to look at the accuracy, the reliability, and the dependability of that data.
Were you in the courtroom when Dr. Mithun testified?
I was.
Okay, and so her explanation for why she did not need to review the litigation packet, you think that's insufficient because you would do it.
Her testimony was she only looked at the case data and she looked at the summary pages. She did not look at the controls, she did not look at the calibration, and she did not look at any of the case blanks that was within that run to assess if there was any carryover issues or any other instrumentation issues. She did look at a very specific part instead of looking at the completeness of the run.
So you must have missed the part where she testified that she had been reviewing the data in the case for all of the reports since at least October of 2025.
I'm gonna object to argument, Your Honor.
Okay, she's asking, do you recall that?
I recall her testifying to that, yes.
And you also said that you were not sure what the dilution level is.
Which one are you referring to? There were several that had dilutions.
On the comforter samples, you're saying you don't know.
I don't know the factors in which they did the dilution. So when I worked in a laboratory, if we ran a dilution, we had to document, we took 5 grams to 15 mils of water to make that dilution, and we recorded that math. So anyone who was reviewing our documents could go back and know what factors and what dilutions we were doing and how we came to get to that dilution. All I have on this is a 1+1. I don't know the amount that it started with, and I don't know how much of the liquid solvent would have been added to it to allow for the dilution to take place.
Okay, well, that is what the dilution level is. If it's 1+1, if it's 1+9, it's 10. If it's 1+99, it's 100. And that is what is listed and documented in all of the NMS values.
I don't know the math.
You didn't understand how to interpret and do the math of 1+99.
No, I understood.
Okay, she can ask her question. Go ahead, you were answering.
No, I understand it. It was not documented on where they derived to get to the 1+99 or to the 1+1. I don't know where she started from to get to that. So in my laboratory, when we would do, in this case, like the liver, we would take 5 grams of the liver plus 15 mils of water to get a 4 times dilution. That math was not provided for the dilution, so I don't know where it originated from.
So you're saying
Well, just because you don't understand the report doesn't mean the report isn't complete.
that you don't know that it was a 10 times solution and a 100 times solution, that you couldn't interpret that.
That's not what I'm saying.
I don't think that's good.
Just briefly.
Brief, okay.
So this defense expert isn't qualified to review other labs based on national standards of certification. So, and these are good points that the prosecution raised. Really negated a lot of her testimony, and she tried to say they didn't do things properly. For example, they didn't do the, which makes sense to me because I'm familiar with a lot of urinalysis tests from my time in the military. They have to have the chain of custody for the vials, and they need to have them sealed. They need to have a log showing who's handled them, how the chain of custody's been processed through all the way to the lab that's going to test them. So some of that wasn't fully documented properly, but the bottom line is, what's the defense trying to say? That okay, this isn't blood from Jade, so Jade didn't have cocaine in her body? Is that what they're really trying to argue? We know most likely is the right accurate sample from Jade. So they're just trying to muddy the waters. They're trying to show reasonable doubts. If you can't trust the science, you can't trust anything the government says, kind of thing. So they're just trying to create reasonable doubt, which that's their job. But in the end, it doesn't really drive any strong points home of they tested somebody else's blood, right? So is anybody really going to believe that? I don't think so.
I wanted to just clear something up real quickly. If you remember, I asked you originally, were you aware of who the liver belonged to? Do you remember that question?
Yes.
And what did you say?
Originally, I did not,
And why not?
because of the way it was written on the submission form and the report. It had the same medical examiner number. It was later on that I learned that it may have been maybe marked wrong. It was the liver of the fetus, not of the decedent, as it appears on the report.
I want to show you.
And there's little nuances to any kind of agency that does report any kind of lab or business. A lot of things are standardized, but just like if you took how police reports are generated in any different city across America, they're all going to have their own little ways of doing things. It's not cookie cutter. Everybody's going to do it exactly the same. The FBI does theirs different from other federal agencies. The military does theirs differently as well. And so it's just the nature of the beast. And so the fact that she's not maybe familiar with this particular lab's way of doing it doesn't mean that it's like critical stuff. So just is sort of I would call it like ankle biting kind of issues here. Now they did say that there was some issue of the comforter having some fentanyl on there, but that's something that is not an indication that that was the thing that killed Jade. But if it was, whatever it was that killed her, she was not consuming it herself. I think that's pretty well established right now through the prosecution's case. So defense hasn't done a lot here today at all, except create a lot of throw a lot of mud against the wall to see what sticks.
is listed here, does it say who the liver belongs to here?
It does not. In my previous experience working in a medical examiner office, if they come with the same labeled as number, it's from the same person versus if it would have been a fetus in the laboratory I was in, it would have been given a daughter number or a separate number so that the testing could be separated.
And that is for litigation packet 2312688 number.
Yes, ma'am.
And did you see anywhere else where the liver was associated with the fetus of Miss Bennett?
Only in the autopsy report.
And I apologize, my PowerPoint didn't work earlier, so I didn't have my paperwork, but you had asked me to give you this.
They're basically trying to say that, the lab work can't be trusted. It's essence what they're trying to say, because they didn't follow all the procedures like the chain of custody. But she even admitted that it's not a requirement to have the chain of custody documentation be proper before the lab could analyze it. And so, they're going to process what's given to them. So the fact that who actually drew the specimen sample is not going to defeat them from doing the testing. So yeah, that's a good point, Lee. The baby's name is Ivy, so we should call the baby Ivy, not a fetus. Thank you.
Document so that you could assign the numbers to the vomit on the comforter. Do you remember that?
Yes, and it was to help the jury understand how I was able to look at the data and relate the data that was produced to the.
They could still call some friends of his to testify about his character, so don't rule it out just yet. But they could start out strong with something like that if they wanted.
Corresponding sample that was running at the same time.
Is
So
this the data that you were speaking of?
yes, so if you see where it says sample ID and then 003 and the next column labeled as low control, and then it has the description of what that control or that item is, that's where I was using that report to look at the data to correspond.
So you're explaining why you were confused on something on somebody else's report of a lab you don't work at. So, okay.
The data to the, you see where it
Patient on the case. Or what were they expecting in the test for fentanyl to show up on the case? If you know.
I would think no, because it's called a blank, which means it should be negative for any analyte in what you're looking for. It didn't say blank plus fentanyl, so.
Any other questions?
Just briefly.
Okay.
Again, Doctor, you were here when Dr. Mid.
Yeah, there's also vomit. The vomit on the comforter tested positive for fentanyl. So there's some trace amounts of fentanyl on there. Let's see. They also found in the blood of Jade, they found the cocoethylene, which means there's a combination of alcohol and cocaine. So.
Testify, correct?
Yes, ma'am.
And she testified about fentanyl being found in a very low number across the fabric. And she talked about the fact that that was kind of noise an issue and it did not mean anything. The level was so low. Do you recall that?
Actually, I think her testimony was that it was present and that it wasn't the noise because she saw both of the peaks in both windows and the ion ratio was in.
Okay, so the issue about whether it was considered noise or not, like was it such a small residual amount? So the prosecution should have the details on this nailed better than this expert.
And she said there was absolutely none of it in the vomit, but it was something that showed up across the entirety of the fabric. Do you
Okay.
recall that?
I don't. I believe her.
Okay, so I take that back then, or at least it's a dispute between the experts here. Was there vomit that had some fentanyl in it or not? So
Testimony was that it was
My
true.
question was, do you recall that? So you're saying you don't recall that that was her testimony?
Not that that was her testimony.
So she already testified about this, but you do agree that when you are looking at any of these levels and you've talked about different levels.
So we don't exactly know what he put in the drink or food that she consumed. So just like we had for the Corey Richards case, right? If there was an effort made by her to poison her husband and she gets some drugs from a drug dealer, she doesn't know exactly what the exact composition is, but there was circumstantial evidence to show that she must have gave it to him, and it was such a mega dose, a cocktail of deadly poisons that it killed him really fast. This is very similar to this situation here. So the defense is trying to put the spin on it that no, she was using it just like we had in the Corey Richards case.
Without giving a ton of specific information, but it is a multi-point inspection. It is not just saying one value, one peak. You have to look at multiple variables that have to be present before it can be reported out. That's the entirety of the standardization and accreditation process.
Object to counsel testifying, is there a question?
I asked her if she agreed with that statement.
Okay, go ahead. Do you understand the question?
You don't understand that when you are looking at lab values or a peak, that it is a multi-point inspection. You are looking at multiple variables and you have to have multiple things present before you can report out that it is a substance that you are finding. That is part of the standards and the accreditation process. If you report it when you don't have multiple variables, that would not be standard process and your lab would not be accredited. Do you agree with that?
I agree that there are multiple facets that need to be met for a analyte to be reported, and that's what the validation process covers. But there also
All right.
it also has both transitions in both windows, and I believe her testimony said that it was present in vomit.
Well, actually, the standards is part of what's in the litigation packet, which is part of the reason Dr. Mitten doesn't need to review it, because she's familiar with the standards of NMS. So you didn't review the standards of NMS laboratories, what you're saying?
They weren't provided in the litigation packet, ma'am.
I don't have anything else.
Okay, thank you. If you could step down.
Thank you for your time.
Rod.
Okay, let's jump ahead here. So still waiting for some dynamite evidence from the defense. Am I going to find some here?
Al, regarding Dr. Larkin, as we were provided with.
Okay, hang on, you're jumping to something else on me now. So you want me to order the defense?
All right, I'm playing it at 1 1/4 speed, so keep that in mind, please.
Who to call first?
Your Honor, I'm simply asking that we have a jury out about this document that we just received.
Let's go back. So you
Another just received document? Really? Wow.
objecting to them playing the deposition at this point?
Yes, because we just asked Dr. Carney to leave her
Job and come over here to assist us with our defense experts, and they said that's who they would call.
You did say,
I never said who I was calling next, Your Honor. I said I had experts today that I was calling. We have not stated who we were calling next.
you want to play the deposition, which is a 50-something minute long.
Yes.
50-minute deposition.
You want her to go, so you want me to order them to do that?
Judge, I'm simply asking if we have a jury out so Your Honor to make a determination if Dr. Larkin will be allowed to testify, because we just received a report that we have not had. It has an opinion and a conclusion about the cause of death of Jake Benning.
I haven't even seen that, Your Honor. So if she gave him a good report, it's not
Wait, your
something.
staff said they had everything.
That's been emailed. When they said that they emailed that over, that is what they emailed
We
over.
have.
This morning, this afternoon, I don't even know if it was morning.
She
Let me see what
prepared
you're-
for her testimony today.
Is it a report?
Yes.
Yes.
Is it a report?
Let me take a look and I'll let you know.
Okay.
Well, I asked the court to make that
Hang on.
determination.
Judge, we received it.
Hang on.
Thank
I
you.
gotta get the definition of what a report is first.
Thanks, Bethany.
Something that she formulated for her testimony.
When?
I'm assuming, I don't have to ask probably yesterday.
Letter, is it a sheet?
Yes, I'm sure it's yesterday.
See if Dr. Kelly Larkin is up there.
No, she's not here yet. She is my last witness. So I was under the assumption that I could call my witnesses in the order that I wanted.
That's normally the case. I was just trying to help do this jury out here while Dr. Carney was here.
She's not here yet.
So let me have that, make a copy of that. Can Dr. Carney come back? Who is Janice Lindsay?
She is a toxicologist.
And who is Dr. Mario Bartolome?
He is a toxicologist medical review officer.
And they're gonna be testifying about, someone said the cause of death.
In regards to Dr. Larkin, yes,
And Dr. Kelly Larkin is what?
she is an ER doctor, a medical doctor.
Not a forensic pathologist.
No,
And you wanna ask her, what, you just found that out, what her opinion is today, so what are you wanting to ask her?
I want to ask,
What is her opinion?
her opinion is that this was more in line with a fentanyl overdose and what she's seen in the ER as opposed to a cocaine overdose.
Based on levels of
So,
fentanyl that are not reported.
so that you're just trying to create confusion because either one of those would kill Jade. So you're trying to just cause confusion on the part of the government. Like we don't know what really killed Jade, right? So that's what defense is trying to do, just muddy the waters.
No, based on the symptoms that were explained and described.
Okay, so back to my question, whether Dr. Carney is available prior to Dr. Larkin testifying, if she does.
She only has a few times so far in this trial today. So that's, Elmar, you're asking, and Letitia never addressed the judge, Your Honor. Is that not normal? That's not true. She never does. She hardly ever does. And it's really noticeable to me. And it's very, very much shocking and disappointing. And I cannot believe you expect to help your client if you're that disrespectful to the court. I'll just leave it at that.
Judge, are you asking if she's available tomorrow based on?
No, we're gonna finish today, I'm talking about today.
She will have things to be here.
Okay, all right, well, I guess we've got an hour-long deposition. Where are the few extra text messages that you're wanting to introduce? Do you have a copy of those?
Yes, they're putting it on a thumb drive.
It's where?
They're putting it on the thumb drive so
I've
that
got copies, hard copies that I can look at and see if it's relevant.
we don't have a printer here, so we would have to go back.
We
to
don't have a
the
printer.
We do, but it's not paper. So we don't have paper here.
You just said we don't have a printer here. Okay, you don't have a. We're out of paper. I don't know. You can't believe a lot of what this attorney's saying.
So we have to go to Ms. Riddle's office. This is
Here,
not our
there's
office.
some paper right there. So
No,
get,
that's not.
no, it's just 30. So get those printed out now, delivered in here to me, so I can look at them, so we don't waste more time. So we've got potentially, I don't know, I guess Dr. Carney, she can be available 4 o'clock or something. Okay.
Time and I don't feel like it was worth protecting.
All right. So you're not convinced either, says Teresa and El Michelle. Okay. So it's just a coincidence that all of a sudden he became interested in her. Think about it. He said he wanted nothing to do with her unless she got rid of the baby. And then suddenly he comes around and changes his mind. And oh, gee, suddenly they both die. Okay. Just a coincidence. Yeah. There's no coincidences in a murder case.
Okay. Have you reviewed some record before your testimony when it just went on? So that's, I don't need to make a ruling on that.
It's not my it's my understanding you do not.
Okay.
I don't know if the defense was asking for that.
We're not.
Okay, let the jury. Yeah.
Just to clarify for Dr. Carney's schedule, Dr. Larkin will be here at 4 o'clock, and we're doing that at 4 o'clock.
I'm just guessing. I don't know how long or how many of the text messages will come in with Mr. Devlin. I don't know how long or how.
These are the messages they gave me previously, and they say they have 30 more. Just for
Actually, it's not. It's
I think they have it.
On and on and on.
Is that Bartholomew? That's not my witness, so no, I haven't. But I'm sure Mr. Jordan will have.
Bartholomew. Let's say, and then he's gonna say what?
In the anything,
Just say yes or
there's no evidence, there's no proof about it, all
Does
this.
the state agree that Ms. Benning could have taken a substance?
And this witness would not materially assist the
So the
jury
answer is yes.
in understanding that.
Okay. All right, we'll have a jury out as to whether he has any relevant information and whether this should have been provided to the state.
Your Honor, I just received a text from Mr. Wiseman in regards to his witness, Dr. Bukalari.
Well-
He is asking if it's possible to put his witness on prior to the planning of the deposition. I told him that I would speak with the court. She should be very short. And
That's
so,
up to you. You said it had to be this deposition then.
I just didn't want it to be Dr. Larkin for certain, but I can
You
accommodate.
said
Dr.
you wanted to
Bukalari.
put this deposition on next.
I do.
So
I
you
don't
want to
mind.
call,
So she thought he's coming around by what? Going to get wasted on cocaine and fentanyl? That's how you're going to win this guy over? A guy that's starting to come around and said, want nothing to do with you unless you got an abortion? Yeah. Okay.
call Dr. Bukalari next or the deposition?
I can, if you'll allow, I will let him know that he can bring her over. She's very
She's
short.
not even here.
And, you know, it seems like
Okay,
he's at.
bring the jury down. We'll play this deposition.
One last thing, do we have anything from Dr. Jancy Lindsay?
We just turned it over.
Is that the notes that you were throwing around?
Those are not even notes. Those are articles that she relies on. It's not Jinx material. It's not anything that we are turning over or trying to admit, but out of an abundance of caution, we turned it over. So we have what we had.
So no notes or no.
No, I don't think there's reasonable doubt. I think that I think there's nothing about Jade's background and the timing of it is so key. All right, and his behavior and how he was going to sneak. He's trying to figure out a way to sneak something into some other girlfriend's drink to force an abortion behind her back. That's exactly what he's trying to do here. It all fits in so nicely. That was his MO. What the prosecution is going to argue.
Give you notes as well.
It doesn't matter what's been said, it could change.
They're not supposed to be, they are.
But of who? What does it say?
They're from Dr. Lindsay. That's what you asked for. That's what you have.
Let the jury step in.
Here. Very painful.
That's not how we had it done. I don't know.
It's going to be here's a
We provide
deposition.
pre-hospital care across a bunch of different service lines, from events to flight to ground transports.
And what is your position?
I'm a critical care paramedic.
Can you explain what the critical care paramedic does?
We provide life-saving interventions in pre-hospital setting.
And that pre-hospital setting, can you describe, are you on an ambulance or some type of vehicle, or where are you normally physically working?
In my current role, I can be positioned on an ambulance, or I can just be in a venue. It just kind of depends on my assignment.
And would you ever sometimes be at Vanderbilt University Medical Center?
Working currently, we're not working at the hospital.
And how long have you been in that position at Vanderbilt?
In my current role since fall of 2023.
And prior to fall of 2023, what did you do?
I was working at the ER at Vanderbilt Adult.
And what was your position?
I thought as I was thinking, I'd be curious to know as a prosecutor, did he tell everybody at the Titans organization and his friends, maybe not his closest friends, but did he generally admit and also on social media that he was expecting little Ivy?
In Vanderbilt's emergency department. And can you describe?
Think about it. Jay did not announce it. She was waiting for her birthday to announce the fact that she was pregnant, right? So you think he would have beat her to it? I don't think so. So again, the convenient timing of this.
What was your role in patient care when you were a paramedic in the Vanderbilt emergency department?
We were mostly support for the nurses. Anything that they would need, IVs, medications, we would work traumas, anything that would come in. We were just kind of support for the doctors and nurses there.
Okay. And that position is an EMT position, but it's a position at Vanderbilt Hospital. Is that correct?
Yeah, it's a paramedic position.
And so there are other paramedics that would work for National Fire Department with ambulance services. Is that correct? Okay. And specifically, were you working as in that position as an EMT at Vanderbilt Emergency Department in February of 2020?
Yeah, I was working as a paramedic.
And were you working specifically on the night of February 25th, 2023 into the early morning of February 26th?
Any doubts you have are just not reasonable, okay? That's my take on it.
And while you were working, were you involved in providing any patient care to patient Jade Benning? I don't remember. In preparation for testifying today, did you review records to verify whether or not you were involved in any patient care related to Jade Benning? Yes. And were you involved in any way? Yes. And specifically, did you ever administer fentanyl to Jade Benning? And did you review records related to whether or not you administered fentanyl to Jade Benning? Yes. And in the records, there is an entry from February 25th, 2023 at 23 and 27 hours that indicates that fentanyl was dispensed. Yes. Did you review those records? Yes. And can you explain, what does it mean when a medication is dispensed?
When we are pulling it from the medication dispensing machine in preparation to either have it on hand to give or to give to the patient.
And did you locate in the records whether or not you actually administered that fentanyl that was dispensed at 23 hours and 27 minutes on February 25th of 2023?
Okay, so that's really, so they didn't have it actually given to Jade. So, okay, so fentanyl, that answers that. I'm just going to jump ahead and move along here.
2259 is not accurate.
That is correct. They have stated that in their case
No,
in
they're
chief.
not stating that. That's accurate. But you're asking about another work order that's not been testified to in the record. So how do we know what the results were?
I'm not trying to get into the results.
But you're
of
wanting
that
an email
test.
to confuse the jury about what's going on here.
No,
Right?
sir, I'm not.
Okay. Well, I'm not allowed this email. So leave
And
that.
no, that's
Jan's nodding her head too.
fine.
All right, let the jury step
I'm
up then.
not done. I have another test. As I stated, there is another work order that Dr. Brugaleri is aware of where Ms. Benning tested positive for cocaine. I simply want her to have the opportunity to testify about that because
What
it goes to
order
my
is that?
clients. It is work order number 2023-0090.
Your Honor,
Tested
Yes, it was.
by Vanderbilt.
Your Honor.
Yes, it was tested by Vanderbilt, but what's in question is what went to CSFRE, which is,
What?
it went to the Center for Forensic Research and Education.
But your hospital tested it and it showed what?
So it went to NMS lab. So our hospital drew it, sent it to NMS
The
lab.
hospital didn't test it.
Our hospital sent it for extended drug screening to NMS. I do not.
Vanderbilt Hospital test what she's asking about.
Could you repeat the question, Your Honor?
Did Vanderbilt Hospital test what this lawyer's asking about?
I don't know if they ran tests on that sample themselves.
She has personal knowledge that Ms. Benning tested positive for cocaine.
Is that accurate?
Yes,
From what source?
that's from the Center for Forensic Research and Education.
She didn't do the testing.
But she has personal knowledge. And
Did you do
she's a toxicologist, Your Honor. And she's treated Jade
You
Benning.
want everything to be reliable, right?
No, what I would like is
I
for
don't want
this,
everything to be reliable.
may I finish, sir, please?
Look at how rude she is. No, I don't want everything to be reliable.
Answer my question. You want all the test results to be reliable.
I would love for that.
Okay.
But that's,
Your Honor. Where's Your Honor in any of this? Where's Judge? I mean, just rude. Rude as all get out.
We don't have the people that did this test. Did you subpoena them?
I don't need the people to be.
Well, then she
there.
can't testify about the results of someone else's test.
She's talking down to him. It's just really, really cringy to see.
She can testify about her personal knowledge
She doesn't
because
have personal knowledge.
she just told you she did.
It's from another testing agency.
It doesn't matter. She got,
Okay, well, I
you can
think
make
you
your ruling, Your Honor, and that's
I
fine.
knew, so that's out.
You can make up ruling. I mean, look at her smart talking this judge. Wow. Unbelievable. Unbelievable. Well,
And what is your
else do you
ruling?
want? I just said it's out.
Thank
What
you.
else do you want to ask her about?
There's nothing else.
Okay, let the jury step in.
Can I get my test back, please?
Sure.
yeah, none of this. Listen, all this smart talking the judge never calls him Your Honor or Judge. I think Your Honor's higher respect than saying judge. So,
Subpoena somebody from the lab.
bailiffs there in the suits. So you notice the bailiffs aren't in guns and badges, visible guns. I'm sure they got guns underneath their jackets. Yeah, this is would anybody want to be a defense attorney and act like that? How do you feel good about yourself? No embarrassment whatsoever? No shame? I'd be ashamed and embarrassed. But you know what? She's not called out on it by the court. Unbelievable. She says, I think, Your Honor, maybe 3 times the whole day or something like that. I mean, you're talking for a couple hours to the judge. The judge is old school, so.
My questions have already been asked.
Any questions from the state? All right, thank you.
Other judges
The defense
would dress down the attorney. So you will call me judge or Your Honor when addressing me. You got that, counsel? You know, something like that. This judge is he's being a pushover when she's dealing with him. I don't get it. He's making proper rulings, but he's not holding her feet to the fire.
calls, Eric Devlin.
I think the jury sees that she's just not being likable in her behavior, but you know, most of the stuff the jury's not seeing. All these shenanigans and tactics that they're pulling.
Get here, somebody, let the lawyers jump in.
Yeah. Yeah. Let me ask you this. Do any of you think she respects and has fear for doing something wrong in front of this judge, botching something in front of this judge? Why? You just can just sass back at him and get away with it? I mean, how's she going to change her behavior? I guarantee if I came there and did that, treated the judge that way,
And let the lawyers jump in.
Yeah. All right, let's jump ahead. It's just very.
Attorney, I'm going to ask you just some, I don't know about brief, but some questions in terms of the bottom line issue they're wanting to call it, okay?
Yes.
Outside the presence of the jury. Okay.
Good afternoon.
Good afternoon.
Can you please state and spell your name for the record?
Mario San Bartolome, Mario. Last name is SanBartolome.
Okay.
And
So this guy is going to talk about some addiction type background he has and how a pregnant woman is most likely to conceal the fact that they're using drugs because it's such a stigma and shame in society. So, okay, well, pregnant women are the most motivated to conceal that? What about people that have really high stress level jobs that could kill a lot of people? What about a surgeon? Do you think a surgeon would openly talk about their drug usage? How about an airline pilot? You think they're going to openly talk about their drug usage, or they can kill a lot of people?
I'm an addiction medicine specialist and family physician.
And can you tell this court a little bit about your education?
Sure. I'm double board certified in family medicine and also in addiction medicine. I'm also a medical review officer, which is the individual that is involved with drug toxicologies as it relates to substances of abuse. And I currently work as an addiction medicine specialist at a community clinic overseeing a treatment and any sort of substance use related things at a federally qualified health center.
And can you tell us a little bit about your education?
Yes, I went to UC Davis for undergrad, right around subsequences.
No further questions at this time, now. Okay. I would ask that he be tendered as an expert as a medical review officer, as well as a addiction medicine specialist.
The state's not so much concerned with his qualifications, but with the relevance.
What do you want him to opine for this jury?
I want him to opine for this. Dr. Mario, in your experience, is pregnancy a automatic stoppage to substance use?
No.
Why not?
Well, because even though it is definitely a well-studied external motivator, in other words, if somebody is in the process of using substances and finds that they're pregnant, it is something that is associated with a higher likelihood of having motivation to stop using. But by itself, it's not something that's a guaranteed that somebody would stop using any substances.
Okay, it's not a guarantee. Okay, how about somebody that's, that's the thing is you cannot bring out this personality defects of the defendant. How about somebody likely to sneak a poison into the drink of a pregnant date that does not want to have the baby and has done that before? Is there a propensity to do that again? A question like that would be really nice to see, but you can't ask that as a prosecutor.
And what is addiction medicine trying to understand?
Well, addiction medicine really deals with judgment. It deals with physiologic changes that drive somebody to have impulsivity, to have the kind of behaviors that can be harmful to them. And despite those things, there's changes in the brain that cause them to continue.
And he knew that. So he knew his best defense would be like, what, she's still using? I mean, that sort of all plays into it.
The behaviors that hurt them. So a lot of it has to do with judgment, and a lot of it has to do with how substances interface.
Can self-reporting in clinical settings, what is your opinion about self-reporting in clinical settings?
Well, it definitely is very valuable. That's what we base all of our screens with. People self-report. It has some limited value in that we are relying that the individual is being forthcoming. And that can be difficult in addiction because addiction also, or even without addiction, actually just with what we would consider substance use. That means no addiction, no dependence, just they happen to use a substance. But
that's some questions about, you're going to win somebody over that doesn't use drugs by all of a sudden loading up on illegal drugs that can kill you? Really? That's the way you're going to win somebody over if you're 5 months pregnant? Makes no sense.
The setting of screenings and things like that, there's a lot of stigma, unfortunately, that's attached to any substance use. And so sometimes people, they have reasons to fear being forthcoming with certain things that have to do with substances.
If you know, can you please explain what is an opioid epidemic?
Well, the opioid epidemic is currently something that we've experienced since around 1999. Currently, we're in our fourth wave of the opioid epidemic, and everyone's probably seen in the news drugs like fentanyl or heroin. These are class of chemicals that typically we use for pain. And the first wave of that really happened somewhere around 1999. And it was around prescription drugs that doctors.
Yeah, and they're also a drug of choice for people to commit murder.
Would prescribe, and sometimes people could get dependent on them. Now, dependency is not the same thing as addiction. It can even just be dependence. It can be around pain. However, it does leave people where if they stop using it, they experience what we call withdrawal. And withdrawal can be a pretty severe neurologic type of reaction to not having the substance in access to the acts.
Let me jump ahead.
kind of use. It doesn't even have one. However, in the case of psilocybin, combusting it or burning it actually would deactivate the active ingredient. So you wouldn't get what you wanted from it. And then you would also be inhaling a bunch of fungal spores into your lungs. So there's lots of reasons why it's something that people don't really do, even though certainly you can try it. What's involved in this is
Jump ahead. Let me try to see across.
Recommendation to that person would be working in a bar would probably not.
Time I would like to tender Dr. Mario as an expert, as a medical review officer, and an addiction medicine specialist. Any questions from the state?
Yes, sir. Well, Doctor, would understand about that
All right. So I think this is, I did not see this part ahead of time. So I think this is the voir dire. So this is not in front of the jury, is my guess, based on the way that was ending there with the question.
by analogy, a pregnant woman
Or the comment about the certification as an expert, qualifications as an expert.
should never work as a bartender. Because they've been around.
I don't understand the question.
That they shouldn't be ingesting.
Well, so for somebody with an addictive disorder that has pregnancy, yes, my recommendation to that person would be working in a bar would probably not be the best, just because of exposure.
There is absolutely no proof in any record that you've reviewed that Jay Benning was addicted to any cocaine or any other controlled substance, is there?
Not of cocaine or no addictions.
And she was a casual user of marijuana, correct?
Well, so we don't use terms like casual user, so that would have to qualify that. I mean, we have what we consider to be misuse of drugs and then use disorders. We can't really make a determination on use disorders because a full evaluation wasn't done. The labs, the examination. She did not have a use disorder that I could state as a physician because that examination was not done. But misuse of substances, there's actually a lot of information. There are chats with.
I'm not asking you about misuse disorders. I'm asking you about Jay Benning. I'm not asking about other people.
I'm not talking about other people. I'm talking about Jay Benning as well.
Well, in California, is marijuana legal in California?
It is. Well, it's decriminalized, so it's
Decriminalized, whatever. And actually legal in a number of states, from what I understand. Okay, do you treat people with marijuana addictions?
I do.
All right, so do they come to you out of the blue, referred by law enforcement?
Law enforcement doesn't give me many referrals unless there's court ordered. However, I do get referrals, and I do have people that come in that tell me that their cannabis use has gotten past what they can handle, and they feel like their life's out of order.
Out of control.
Yeah.
Absolutely no indication that happened with Jay Benning, is there?
I would consider engaging with a drug dealer unusual behavior that would be linked to, in this case, cannabis.
That's my point.
From the text messages that she was having between Danny, the dealer, she was getting for her coworkers and for herself, cartridges of cannabinoids, all sorts of different species of cannabinoids, some magic mushrooms. I'm sorry? She was brokering them. Some of it was promised to her, but most of it was as an intermediary for coworkers.
Yeah.
I would consider that to be unusual behavior, I think, for anybody to engage in that, because the risks are high. Not judging if it's a good thing or a bad thing, but to put yourself in a position to have to be an intermediary and then potentially be at risk for the consequences when you give somebody else a substance that somebody else brokered for them.
From the records you reviewed, we're talking about Adderall. There was no Adderall or any derivative of that found in Ms. Benning's system, was there?
No.
And
So he's trying to say that it was likely that she was still using drugs during the pregnancy just based on who she had some emails with, the fact that she was being a broker for others.
you and I talked, and we have a time or two, we're to say hello, that you would agree, would you not, doctor, that she died from acute cocaine toxicity by oral ingestion, correct?
Well, I'm not here to actually, my scope is not to testify on cause of death. So I would leave that to the toxicologist and Dr. Larkin.
Well, did you not tell me that you would agree with that finding?
Objection, Your Honor. What if it's already stated? It's scope. Yeah, I was just saying.
Right. And that, how many people have you ever treated at your clinic or for being addicted to orally ingesting cocaine?
That's exceedingly rare. I mean, I know that people use it in their gums, they've had it in their mouth, but there's definitely not been a lot. That's not, actually, in general, that's not a common way. Yeah, so.
Because they die.
No, that's not why. It's because it actually takes longer to get the effect, number one. Number two is because it actually deactivates a lot of it. So it's hard to get the same effect that you could get if you snorted it, you smoked it, or you injected it. That's the reason why. And there's quite a hierarchy that can be applied to most things, actually. If the particular substance isn't particularly absorbed well with how you take it, that's not how it's used.
There is absolutely no indication, doctor, is there from a medical record that Jay Benning consumed any drug or alcohol after she found out she was pregnant? Is there?
Correct, not medical records, no.
Yeah.
And so nothing.
I think maybe would his opinion change if he saw photos of how happy she was with her baby in the womb and rubbing her stomach. We saw that video yesterday. So I bet you this guy hasn't seen all the evidence.
That you have testified about is based on any personal interaction with Jay Benning, correct?
That's correct.
Either during her lifetime or from obviously the review of the records. There is just nothing there.
Yeah, I have not personally evaluated Ms. Benning.
And the phases of heroin has nothing to do with this, does it?
No. Are you referring to the different?
They're epidemics.
Yeah, well, they're not mine. They actually are ours, but I mean, the heroin was just one stage of that, and so that was just one to kind of explain why there are different stages of that exist. That the most recent one is fentanyl and psychostimulants.
But your testimony about the phases, what was before heroin?
Before heroin was prescription drugs.
Before prescription drugs?
Well, that's the first one. Prescription drugs, then there was heroin, then there's fentanyl, and then there's fentanyl with psychostimulants. That's the four. And we're likely to enter a fifth one now with xylazine, which are like anesthetics that are being adulterated into the supply of fentanyl.
And back in the 70s, there were other substances.
Back in the 70s, one at a time of what was available. So I'm not really speaking to that.
That's all.
Okay.
Thank you.
Step down, step back up. Oh, you got more quick?
Dr. Murray, can you explain what cocaethylene is?
Cocaethylene is a byproduct.
All right, Jack. Wasn't covered on direct or cross-examination.
Okay.
I thought it was a jury out.
Treatment. Specialist addiction medicine.
Yes, sir. I mean, cocaine and alcohol was just referenced.
Is that what you plan on getting into with Dr. Larkin if she testifies? We've already heard testimony about it, right?
Yes, Your Honor, but however, what was just elicited from Dr. Mario was about a person working in a bar, and was there ever any evidence of any uses of cocaine with Mrs. Bennett?
Is he aware of any usage of cocaine?
Are you aware on whether or not the substance cocaethylene was found in Ms. J. Benning's system?
Well, my understanding is that there's one of the lab reports that did show that there was cocaethylene. It sounds like there's probably contested. It's maybe for the.
And what is cocaethylene a byproduct?
Well, so when you consume alcohol in the setting of cocaine, you produce a compound called cocaethylene. It creates a high toxic environment, so your heart will work harder. All the things that normally cocaine will cause, it can make it worse, and it's one of the known problems, right, with combining those.
And can alcohol be an addiction? Can it be abused?
Yes.
Can it be misused?
It can.
And can you be a casual cocaine user?
You can. You can be a casual cocaine user, somebody that uses not with great frequency. It's possible. It's possible with alcohol as well.
Any other questions?
So you can be a casual cocaine user, but not a casual marijuana user?
I don't think I said you can't be a casual marijuana user. That you can't be a casual, and I don't think I would have said that. I mean, if I did, I misspoke, but you absolutely can't. You can be a casual.
You wouldn't use the word casual.
Yeah, I wouldn't use casual because in the context of what you were talking about, it was.
He's asking you to be a casual cocaine user.
So you can be. So if the definition of that is that somebody uses infrequently, If that's what your definition is, when we discussed the issue of the marijuana, I thought you were talking about something more like diagnostic. I just wouldn't use those words for something diagnostic, but they both can be used with low frequencies for sure.
You know, how about a question like, how easy is it to buy fentanyl or marijuana, or I guess not marijuana, but fentanyl or cocaine on the street in a place like Nashville? You're not from here, but how easy is it in any type of environment where there's people going out at night, type of bars, restaurant bar type of situations? Where do they find these drugs? You know, how long would it take to find somebody to, if you were like here in Nashville, how long would it take for somebody to find drugs? You know, something like that would be, I think, helpful to show that somebody who doesn't have a history using drugs could easily find something and spike somebody's drink if they wanted to cause some damage.
Dr. Copeland, Ethylene, you said someone told you about that?
No, I've seen it in the reports from one of the labs, but again, I'm not here to testify in my scope about that. I think you have a toxicologist and you're going to have Dr. Larkin on that.
And
that's possible.
Prepare a report about all of this?
I did not. I don't have a report.
That's all right.
Anything else? Oh, okay, you step back up.
Yes, Your Honor. Yes, Your Honor. Say, renew his objection to this doctor testifying under Rule 702. It's meant nothing that he has testified about. In fact, knowledge of this incident,
All right.
no knowledge of this being, other than she was not addicted. All this testimony would have to come under Rule 702, that it is would substantially assist the trier of fact jury. And
See, if I was the prosecution and I have all these expert witnesses, I'd be doing things to object ahead of time, not at trial. You're holding up the jury, and make this guy come in from California twice, or make him be available via Zoom to testify and establish whether this is relevant or not. You know, holding up the jury like this is just bad timing.
Merriam-Webster dictionary, synonym is important or essential.
All right, we don't need this argument.
Donna, it is not only important, but it's a vital and critical issue that the state has put before this jury through multiple witnesses, which is the fact that Ms. Benning would not engage in any type.
I think psychologically how somebody may react in a certain situation, I think that's okay to admit that in a fundamental fairness. So I know as a prosecutor before, I brought in a psychologist to talk about a rape victim and how the behavior post-incident was consistent with someone who had been raped. So you can't have them vouch for someone being a victim, but their behaviors were consistent with rape trauma syndrome. So I think this is along those lines. So I think the judge should allow it.
Drug use or behavior because she was pregnant. And so it is very.
They didn't say that. They said there's not any proof that she did.
And Your Honor, we believe the contrary.
But not to talk about Jade specifically, just talk about in general, just talk about generalities. That's what I think is the key.
We intend to get into that.
But this gentleman doesn't know that.
Yes, he does, Your Honor. He has reviewed text messages that suggest she was offered drugs while she was in fact pregnant.
We ain't got the text messages, but if those come in, then they come in. He doesn't have to interpret them.
No, but certainly they are evidence of the lifestyle that Ms. Benning was engaged in. The state certainly has taken the position that
testimony about so.
However, Your Honor, she is heavily involved with the sale of drugs.
Right.
That is dangerous behavior in and of itself.
Heavily involved. There's no evidence of heavily involved.
The jury needs to be educated in regards
And
to.
what proof is there that she was involved in dangerous drugs on the day or in and around the day she died?
Because on that very day, she reached out to her drug dealer. The very day she
Any
passed,
proof that she met with you?
we don't know.
Okay. Well, your doctor
You don't have anything indicating she ever asked for cocaine or fentanyl, okay?
Larkin says on the day of her death, text messages indicate that Jade met with her drug dealer. You just said that in school. And I wrote 20.
All that should have been done pre-trial, wait before the jury got there.
Mr. Devlin,
Devlin, raise your right hand if you swear.
So I guess that guy didn't testify. Is that fair to say? He got dismissed? I guess that's why some of you said he dismissed. I didn't get that far in the case today. I did see this guy, though. This is a guy from Texas. He's a former prosecutor, even tried homicide cases, and he does digital forensics.
Mr. Devlin, could you please state and spell your name
His name's Eric Devlin.
for the record?
Sure. My name is Eric, E-R-I-C. Last name is Devlin, D-E-V-L-I-N.
And Mr. Devlin, how are you employed, sir?
I'm currently the managing director of the Lone Star Forensic Group, a digital forensics company based in Houston, Texas.
And could you give the court your credentials in regards to the digital forensics?
I have an undergraduate degree in history, political science, and film at Southern Methodist University. I have a law degree at South Texas College of Law.
You know, I don't know. He goes from being a lawyer, felony prosecutor, to all of a sudden doing forensic type stuff, forensic extraction, sort of like a Whiffen type guy from the Kieran Reed case. But in essence, he just talks about how texts between Jade and some guy, Danny Weed, were about acquiring drugs for a coworker. Okay, so that's what this guy is brought all the way in from Houston. So obviously they're using some other experts they've used in other cases in Texas to bring in there to Tennessee. And not sure you want to bring in so many out-of-state experts when they're not locals. And locals buy into what locals say more than they will somebody from out of state. So that's just sort of human nature. So, Patty, you think this guy actually helped the state's case? So let's go ahead and listen to some of it then.
And the application was installed previous, so.
Can you give us a date that this application was installed on this big phone?
I show an app.
Jump ahead.
In the Axiom software.
When I was, sorry.
Did you not do that?
I did enter Bumble as a search term, that's correct.
Okay, but you missed where she got a text message from Bumble with her registration code on August 6th of 2022 at 12:17:27.
Your Honor, if I could just note, that might have been during the date limited portion of our search.
No, you wanted to go back to January 2022.
I don't think you're allowed to go back on those issues. You were limited to certain issues that we could search.
No.
Well, you're wanting this witness to testify about her access to bundles. They're asking their question. Go ahead.
That is not what happened.
Let me jump ahead.
Just like these others. But that's
Price cut on 2+.
Could I draw your attention to page 8?
Yes, ma'am.
Could you explain to the jury what this represents, what page 8 represents?
This is an actual iOS text message. So this is a communication between this particular device and another individual. That individual they're communicating with is phone number 501-451-0608.
And could you read for us the text message?
The text message start at 11/22/2022, 10:40:13 a.m. Do of your coworkers get Adderall? The reply, Lauren has some. Message again, what MG? The reply was 15. Message to this particular device, ask her, can I buy some? And then the next was a follow-up. This is still a message to this particular device. And what color are they? And the reply from this device was orange.
And to the left there, who do you see is the sender of this text message?
The sender of this message is this number is listed in the contacts as belonging to, and I'm going to kill the name, Nijaha, Nijaiha.
Nigeria?
Yes, ma'am.
Najee Jackson.
And what is the date of that text message, sir?
11/22/2022.
Can I draw your attention to page 9?
Yes, ma'am.
And could you read for the jury what page 9 represents with the date?
This
as
is,
well as the context.
this is an iOS text message, and this is between the Jade Binning account and Mario Gutierrez account. On this message, it occurs on 2/18/2023, 9:33:02. The message was from the Jade Binning account saying he's about to bring the weed. There's a reply from the Mario Gutierrez account, says, I fell asleep, and I don't know if I'm allowed to curse in this courtroom or not. So,
That's okay, thank you. Could you please turn your attention to page 10?
yes, ma'am.
And could you represent to the jury what page 10 represents?
Page 10 is a iOS communication between the contact Danny, in parentheses, weed, and this particular device. On this one, the message is, I have mushrooms right now. LOL, my coworker's wanting some.
And on what date is this text?
Coworker, not her, a coworker.
I appear to have cut the date off on that text message. I can't tell you.
Okay, thank you. Would it be between the dates that you have listed there where it says first message, last message?
Yes, ma'am.
Thank you. And those dates would be between April 6th of 22 and 2/25 of 23?
Yes, ma'am.
Could you now go to page 11?
Yes, ma'am.
And what does page 11 represent?
These are text messages, specifically occurring on 2/25/2023, 9:10:46 a.m.
And what does the message say?
The message says, yo, can you holler at Danny? Your boy needs a half, please and thanks.
Now, I don't see who this message was sent to. Do you have that information, Mr. Devlin?
I do not have that information.
And what date is on this text?
This text here is 2/25/2023 at 9:10:46 a.m.
On page 12, can you tell us what page 12 represents?
Page 12 is a text message between Jade Binning and the contact Danny Weed. And it occurs on 2/25/2023, beginning at 3:39:21 p.m.
And what does it say?
Specifically, it says, hey, my coworker wants to get a half from you. The account Danny Weed replies, bet I gotcha when I get back. The account for Jade Binning replies, sweet.
Now, did you ever find through your research whether or not page 11 was a message from Mario Gutierrez?
I got to be honest, I don't remember. So,
Thank you. I want to draw your attention to page 13.
yes, ma'am.
Now, before we move on, were those all of the text message that involved drugs in between with Jade's phone from January of 22 through February of 23?
No, ma'am. They were a sample.
Let's now go to page 13.
Hey, River Life, no footage from inside the cam at Jay is also disappointing. Yeah, I wonder, she didn't have a subscription, but that's the same kind of thing that we saw in the Nancy Guthrie case, right? So they were able to go directly to the Ring producer, I think it was, and despite not having a subscription, an active subscription, they were able to get that footage.
What section would this subject matter address?
I was asked to look for conversations about Blaise Taylor.
I want to draw your attention to page 14.
Yes, ma'am.
Please read for the jury the text message.
This is an iOS text message starting 12/31/2022 at 2:55:57 p.m. from the account 501-541-0608. Send a message saying, I'm interested. Followed up with another message of, did you text or are you just going to wait? The account belonging to this particular device replied, he called me back. And then a second reply of, I told him that I would call him when I get off. The account ending in 0608 replied, oh, I don't know. I didn't know you answered. And with a second reply of, how was his tone?
Do you know who this number 501-541-0608 belongs to?
I believe that's the same name that you gave me earlier that I butchered. So,
IJ.
Yes, ma'am.
I want to draw your attention to page 15. And what is the text message thread, please?
On this one, it's a continuation from the previous page. It's the account belonging to this particular device that replies, he sounded the same as always, but I could tell he had something he needed to talk about, of course. The account ending in 0608 replied, why am I anxious like I'm talking to him? This device's account replies, LMAO, because I've been waiting for this. The account with 0608 replied with, get off work already, LOL. The account for this device replied, right, I keep looking at my watch. And then the final message on there is a reply from the 0608 account, keep me updated.
I now want to draw your attention to the next section. Could you tell us the subject matter of this next section?
On the next one, there's communications with Blaise Taylor.
And can I draw your attention to page 17?
Yes.
Can you please read that text thread for us?
Yes. In fact, I'm sorry, these are smaller, so I may read it from the larger screen. This particular account, the local user account, initiated a message saying, thank you for coming to help/see the new place. I'm glad we got to talk about all that we did. It gave me a better understanding on some things I didn't have before. Hope you feel a little better as well, names, with an emoji. The reply was from the phone number ending in 5738. Thanks and no problem. Just want to keep communicating and stay on the same page. The second reply of loved. Thank you for coming to help and see the new place. This account replied 100% agree with you. Another reply 100% also turns me on when we have our talks. The account ending in 5738 replied laughed at 100% also turns me on when we have our talks. With another reply of why LOL. Then another message of I feel like most of the time it's really me telling you stuff you probably don't want to hear.
Now, in regards to this text message, is this Jade Benning's phone in the blue?
It is.
Can we now move to page 18?
This is a continuation of that text thread. The account ending in 5738. I feel like most of the time it really me telling you stuff you probably don't want to hear. The next message was from the Jade Benning account. Not necessarily. You're just keeping it real at the end of the day, and that's all I ask of you. And because to see you serious for one, LOL, and us being able to calmly communicate about the situations we have in front of us just lights me up. The account ending in 5738 replies, LOL, okay. Well, I said I'll always be upfront and answer any questions you have. This account here for this device replied, purchase. And this device, this account, the one ending in 5738, was under the contact name of Blaise.
Thank you. Let's now move to page 19. And what subject matter is this section?
This specifically is related to messages regarding plans with Blaise Taylor.
And can I get you to turn to page 20?
Yes, ma'am.
And could you read for us the text message here?
This message was on 2/25/2023 at 12:03:10 p.m. The message was sent saying, okay, LOL, I'm going to plan to do a little at-home paint with Blaise tonight.
And what date is that text message?
2/25/2023.
Can we now move to the next section?
Yes, ma'am.
And what section is this?
The label on it is Bumble.
Can you please identify page 22 and explain to the
Plans with Blaise. That's all you have to show that this, he was really had a change of heart and he's willing to date her again despite her having a child. Really?
jury exactly what this is?
This specifically is a set of logs related to the installation of the Bumble application.
What is the Bumble application?
Bumble is an application that's on both iOS and Android devices. It's described as a social contact application.
And what day do you see that this particular phone installed the Bumble application?
There is an install of 2/17/2023 and another installation date of 2/22/2023.
Yeah. So if she really took him serious, you're dating looking to date other people. Yeah, come on.
And can I draw your attention to page 24?
Yes, ma'am.
And what is the nature of this section?
I was asked to find some communications related to Jarius Porter.
And can you read for us on page 25?
Yes, ma'am. On page 25, the communications start 12/17/2022, 9/17:30 p.m. It's a message from this particular device to the porterjarius@gmail.com. You've been getting it the last few. The porterjarius@gmail.com replies, "Yep, I'm on my way back to the shape I was before. I started dating a world-class chef." The message, this particular device replied, "LMAO, I heard that." And then a second reply of, "That's good though."
Okay. And can you move now to page 26?
Yes, ma'am. And these are, there's a lot of messages in between, but it was designed to give basically an idea of the length of the conversations. So these messages occur on 1/24/2023 at 1:12:02 p.m. This message from porterjarius@gmail.com. That's good. I'm glad you have to.
Let me,
You want to switch to?
yes, please.
Switch to the other.
I'm sorry, do I continue? Oh, sorry. The message was porterjarius@gmail.com, 1/24/2023, 1:12:02 p.m. Message says, that's good. I'm glad you have to. I'm just honestly sad, but I know I want it to be forever, and God make no mistakes. Glad you're feeling better. This particular account on this device replied, yeah, I know it hurts to know, but you can talk to me about your feelings if you want to express anything. I want you to take care of yourself better and not let yourself go down the path of just turning to drinking and smoking more to heal. The Porter Jarius account replied, of course, Shawty, and LOL, don't forget, working out too. It's some good going on too, but you're right, I've been planning on slowing down. This device's account replied, I know you're working out too, LOL, but still, don't be doing that extra stuff.
And
Drinking
the
and
next
smoking weed, is that what Jade is telling somebody?
text message that you have.
This was a message, actually, I'm sorry I printed out in black and white, but this was a message from this particular device, specifically saying, Blaise told me last night he signed up for monthly subscriptions of diapers from this company, Kudos, LOL.
And what's the date, I'm sorry, on this text message?
1/10/2023, and I can't read the time, so.
Really starting to sign up for subscription of diapers? Doesn't that sound staged? That actually, I think, helps the prosecution. Why would he sign up for a monthly subscription of diapers? So in January, the baby would have been 4 months old. So he's going to start getting a subscription and have him be delivered when there's 5 months to go before the baby's born, baby Ivy is born. Unbelievable.
No, I just need to move it over.
7:42?
Yes, 7:42:10 p.m.
That's very incriminating. It's almost like the breadcrumbing is taking effect now, right?
And can we get you to
A setup. This is part of the setup. That's what I'd call it.
read this text message?
Yes, this was a text message from the account 1501-231-5975, asking the question of this.
Do you say if he really does it much? No. Sometimes, yeah, okay. He's not.
Device is Blaise.
Change from him. No way are you having a baby to, hey, I'm all for it. I'm even going to get diapers. Really? You had to change your heart that fast? Really? When he had really nothing to do with the mom? That doesn't make any sense. And then he's in love with this Xavier? None of it adds up. Jury's not going to be that stupid and buy this defense smoke and mirrors game here.
Rub your belly, LOL. This particular device replied, sometimes.
And do you know who the number 501?
That's a good point, Ruth Ann. You know what? Why don't they do a digital search and see if he actually did? See, as a prosecutor, you should be doing this to this is one way if the defendant doesn't testify, you can prove that he's lying. You look at what he texted, and then you see from his computer records and phone records, even if you don't have the phone, do a forensic search and see if he actually signed up for anything. Did he Google for that? I mean, I don't know. The prosecution's sort of leaving some of this there.
1-231-5975.
Hopefully it won't come back to bite him. I don't think it will. I think it's still very clear. This guy's just giving her song and dance.
I don't think I do offhand, so.
There were other messages. Oh, I'm sorry. What is the date? I apologize. On that text message. If you remember before I pulled it up.
I do not remember before you
Let me
pulled it
grab
up.
it.
Those messages were 1/25/2023, began at 9:30:11 p.m., ended at 9:30:35 p.m.
Mr. Devlin, in your search within Ms. Benny's phone, did you happen to run across a text message between?
Objection, Your Honor.
Okay, let the lawyer.
Yeah. Yeah, no way. No way she did this. Okay, let's jump ahead here.
Recall that, but I couldn't give any details on it. I've seen a lot of messages, so.
And you don't remember if Ms. Jackson, Nigella Jackson, asked Ms. Benny when she was going to post about her baby?
I remember that specific message of when are you going to post?
When Ms. Benny responded, do you remember it having anything to do with Blaise Taylor?
I don't recall the response, so.
Thank you. Okay.
Thank you, Your Honor.
Mr. Devlin, you have gone through and testified about some random text messages. Would you agree?
Yes, ma'am.
Okay. And so when you said that you went through Ms. Benny's phone, did you actually take the text message that you have in your page 4 of your report? And did you actually look at the other messages surrounding it to see what context it was given? Which, Your Honor, I'm going to ask what he's doing right now on that tablet.
He's scrolling through his.
Are you looking at the report?
Yes, ma'am.
Okay.
I'm trying to see what was on page 4,
Yes,
so.
no, I'm happy to. I just didn't know if you were looking at the extraction.
Oh, no. Did I see the messages, the context of messages? I did not.
Okay, so you didn't look at the messages that actually preceded Jade's message to Danny, where one of her friends said, "We please top shelf an 8." And Jade responds, "Okay, I'll let you know when he's gonna come."
I'm sorry. Yes, I did see all of that. That's absolutely correct.
Okay, so this message that Jade sent, like, could I get an 8? She wasn't referring to herself because she was getting it for one of her friends.
My reading of it was that she was getting it for somebody else.
Okay. And then same.
And you know what, that California doctor that said she was also taking some of it, there's no email, I think, that talked about that. So that was a misstatement on his part. That's a pretty severe misstatement if that would have came out to the jury. So anyway, just keep that in mind.
Thing with page 5, there are other messages that reference apple fritter, and Jade was seeing if anyone wanted this because she regularly would get different weed from Danny Weed for people that she worked with.
I mean, that particular set of messages was a frequent post within that Telegram group. So.
Okay. And going to your page 8.
Yes, ma'am.
Okay. And so your page 8, that is not Miss Benning. That is one of her friends asking for Adderall, correct?
Correct.
And did you actually read through that message thread with Miss Benning and her friend had a valid prescription for Adderall? Did you notice that?
I remember the discussion of that, yes.
Were you familiar with the Adderall shortage that the pharmacies were having during this time frame of November 2022?
I'm not familiar with that. So.
Okay, so if pharmacies were out of Adderall during that time, which actually, if you read through the text between Ms. Jackson and Ms. Benning.
I wish the prosecutors would bring those kind of details. I'm telling you, prosecution loses cases because they don't bring in enough details. So
they actually talk about the fact that Walgreens can't get it and everybody is out of their Adderall prescription from their doctor.
Okay.
Okay.
Yeah, so you didn't see that part of it?
And then, so this one, I would like for you to look at page 9, skip page 10 entirely, and look at page 11 and 12.
Yes, ma'am.
Okay. Did you connect page 9, 11, and 12 in any way?
Did I connect them? I don't guess I understand your question. So.
Okay, well, page 9 is actually the last message in a sequence of messages, but you put it first. And then when you go to page 11, you left the other person off of this thread, which is readily available in the extraction, but you left off Mario Gutierrez as the person asking Jade, can you holler at Danny, your boy needs a half?
I do recall that. Yes, ma'am.
Okay, so that's Mario Gutierrez, but you left his name off of this.
When I pulled it, I don't think it was included in there, but that's correct. I believe it was Mario Gutierrez.
Okay, and then page 12 follows where Ms. Benning asks Danny very specifically, and this is on February 25th, my coworker wants to get half. And Danny responds, bet I got you when I get back.
Yes, ma'am.
Which, and I apologize, page 9 doesn't actually relate other than it's from that Mario thread.
The time that Mario gets anything is on February 18th, but your report listed 2 dates. It listed the 25th, which kind of inferred that the messages you included in 11 and 12 were on the 25th. But no one meets Danny on the 25th. You would agree with me about that, wouldn't you?
I have no idea if anybody met Danny on the 25th, so.
Because there's absolutely nothing in this Biddings phone that indicates that happened. It's the opposite. Danny said, I'm not here. I'll hit you when I get back.
Interesting.
I do recall that further messages where he said, I'll hit you when I get back.
Okay, and on page 13, this section is labeled a conversation about Blaise Taylor. And that conversation, that's not the only one, correct?
There's quite a few messages about Blaise Taylor.
Okay, and this is from December 31st of 2022. And then again, the next section that you have that begins on page 16, that is not the only communication that they have, correct?
No, they had quite a few communications.
Okay. And then we get to page 19, which is plans with Blaise
Good summary crossed by the prosecution here.
Taylor. And again, on page 20, for some reason, even though it's in the extraction, you left off the person Vinny was speaking with. And this is from the date of 2/25/23 at 12:03. She messages her best friend, Nigella Jackson, to tell her that she's going to plan to do a little paint with Blaise tonight. So you didn't put in the thread that they were talking about where to get the paint and maybe Dollar Tree would have it.
There was,
That
I
would
remember,
be connected to why she stopped at Walmart.
I remember all those communications. I know that there were some, even some pictures. I believe there was a picture of the crib as a part of it. There was talk about what they were going to paint. So I mean, there's a couple of those messages. Yes, ma'am.
Nothing about drugs. How conveniently left out by the defense. Hey, we're going to have some great stuff tonight that I got from Danny Weed. None of that.
Okay, and then on page 22, you have this Bumble information, which you have an install date. But you didn't include the message that showed that Ms. Benning registered for Bumble in August of 2022.
This was when I ran this particular search term. This is what came up. But we talked about those messages before.
You know what I would do as a prosecutor is ask him who decided to select these certain extracts of the text message history. Was it your choice or whose was it? And then he'd have to say it was Letitia's. So it just makes it look sneaky, I think, if you bring out the fact that defense counsel one that asked him to make these extracts to put on slides.
I did see a message back in August of 22 that showed a previous registration for Bumble.
And did you notice that the app was only in focus for 119 seconds?
Not very long.
It was very quick, wasn't it?
Yes, ma'am.
And you don't have any user data to show what was happening when she accessed that app.
Correct.
And so like, if I thought that Kendall had a Bumble profile and I just wanted to go click on it to look at it, to kind of give her some feedback as a girlfriend, it could have just been that.
Absolutely.
And then you included some random messages with Mr. Jerry Porter. Did you notice that they were very close friends?
They appeared to communicate quite a bit. So during that period,
As very close friends.
I don't know enough about them. I just know I was asked to pull these messages. So.
Okay. And then the last messages that you apologize for being in black and white, so they don't have a page number. Do you know what I'm referring to?
I do know the message you're referring to. So.
Okay, so this is January 25th of 2023, and it's just a message from Jade's mother asking her, does Blaise rub your belly? And Jade responds, sometimes.
Right.
Did you keep reading the messages on where her and her mom actually messaged back and forth and draft a message from Jade to send to Blaise to tell her how much she wanted him to go to her OB appointment where she was going to find out the gender of their baby?
I recall something along those lines. Yes, ma'am.
Okay, and you recall the messages where Blaise Taylor did not go to that appointment, correct?
I'm unaware if Mr. Taylor went to that appointment or not.
And rather than verbally questioning him on this, how about you just have the printout and show him? That's what I think would be better. But I think still the point is made. Jury gets it. Very cherry picking by the defense.
So you didn't look at those messages where he didn't show up?
I read through them. As to whether or not he did or didn't, I don't recall that. So.
Well, do you recall that he never went to a single OB appointment with Jade?
Objection, speculation, this witness doesn't know that.
Okay, you can ask whether he reviewed any texts about that.
Did you review any text messages?
There you go. He wouldn't know if he attended any or not. Of course, there'd be text messages if he was going to go there.
Where every time she had an appointment and asked him about it, he didn't go.
Objection, counsel is testifying. And
Do you recall any text messages about appointments?
No, Your Honor. No, Your Honor.
And the last
Then have the you know, if he declined to go, then have those kind of messages and present them, prosecutor. But
message where Miss Benning tells her mother that Blaise told her the night before that he signed up for a monthly subscription for diapers from this company. Did you find any other mention that proved that Mr. Taylor actually signed up for a diaper subscription?
No, I did not.
there you go. All right.
Thank you.
Any other questions?
Set up. Get her back in
Mr. Devlin, you were just asked
close proximity.
the nature of the relationship between Jarius Porter and Miss Benning, weren't you?
Correct.
All right.
Were you aware?
I don't need to hear this anymore. All right. So moving on.
When you got into the 500,000, 98,000, those kind of numbers.
No, I didn't.
I'm not talking about you, I'm talking about the state.
Judge, I'm sorry, I have the same standing objection that you shouldn't be talking about any work order that is not entered into evidence.
We don't
Okay,
want to.
That's fine, I think they're.
All right. Let's see here.
Yes, sir.
Yeah.
This weekend. Report this morning about 10:30 maybe, and I sent that to Letitia and her team.
Any questions from the state?
Dr. Larkin, how long have you been working on this?
That was just very quickly putting that together.
No, she didn't ask that. You're talking about it, the case?
Right, how long have, you said that you just at the end put your analysis together that you've been working on. How long have you been working on your analysis?
I think I got asked to, I think when originally they were in Nashville a few months ago, I was told about the case, and then more recently, I've done work on reviewing all the records, and that's probably within the past month or two. I don't know for sure, but more recent. It hasn't been years or anything.
Okay, so maximum 2 months, maybe a month, you've been reviewing records related to this case.
Approximately, I don't know exactly when I started. I'd have to look at when I started getting some information, but
Do you have documentation about that with you?
I don't have it on me. I could find it out, but it's been several months. I would say on the outside, if you want a number, maybe, several months, something like that.
You said 1 to 2, now you're up to several, which one is it?
You don't object to this line of
Okay.
questioning. This
Is there something in your phone or something you have today that you could tell us? Look up and tell us.
I can tell you.
Okay, yes.
We reached out to her prior to the last trial. She was not officially retained at
That
that
was in
time.
January.
Yes, it was.
Okay.
However, she did not start actually digging into the trial until probably maybe 2 to 3 months ago, before she got everything that she needed.
Okay, what other questions do you have?
Did you take notes along the way?
So that, no, I don't, I guess I put the notes into there. I
It's out
don't
there
have any
for
other notes
jury.
that I've taken, if that's what you're asking.
So no other notes, and you put that together this morning,
She said this weekend, last weekend.
Yes,
last weekend, but you didn't send it to anyone?
I did not until today.
Were you instructed to not type up a
No,
report?
I object. I object.
Oh, I object. Did she actually say Your Honor? Let me see.
No, I don't, I guess I put the notes into there. I don't have any other notes that I've taken, if that's what you're asking.
So no other notes, and you put that together this morning,
She
No,
said
ma'am.
this weekend, last weekend.
Yes,
last weekend, but you didn't send it to anyone?
I did not until today.
Were you instructed to not type up a
No,
report
I object. I object to that line of questioning because
Yes,
last weekend, but you didn't send it to anyone?
I did not until today.
Were you instructed to not type up a
No,
report?
I object.
She didn't say Your Honor. She's saying, not Your Honor. I just,
Object to that line of questioning because what I tell my expert is confidential from Mr. Taylor and his constitutional rights. She
Do you have
doesn't.
any other?
No, it's not with an expert. When you talk to him, what you ask him to do, all that, that's just, man, that's just so, and the judge just lets her get away with it, making up stuff like that. Really?
Questions other than that?
No, it's not your honor.
You really believe that?
All right, thank you.
Thank you, sir.
She's not your client. You're trying to have her be an expert. So all the contact, think about the Kieran Reed case, how ARCA was just made to be out some kind of slime balls by the prosecutor Brennan for using Skype. Was it Skype or some other type of chat service?
Okay, here's what Rule 16, the rules of discovery under the Tennessee Rules of Criminal.
Okay, you know what? So I haven't seen this yet, folks, but the fact that she had notes for at least over a week and the defense never presented these to the prosecution, and she's blocking what she was told for this witness to do, whether to generate and send those notes or that report. So something like this, I would probably, as a judge, block this expert from testifying. You got to punish the defense sometime. I mean, how many of these experts are going to bring in? The same thing has been going on over and over today.
Procedures say dealing with information subject to disclosure by defendants. Inspect and copy or photograph books, papers, documents, photographs, tangible objects, or copies or portions of these, if within the defendant's possession intends to introduce them. That's part A of that B1A. In terms of,
and there would be just reciprocal discovery. So there's a requirement, I'm pretty sure, that defense is required to submit that over to the prosecution.
our discussion about what a report is, that's under B, where it says reports of examinations and tests.
Just don't put report at the top of the sheet of whatever they work. And then as a defense attorney, you can just argue, there's no report, Your Honor. There's no report. It's just notes. It's just notes. Everything they prepared for me to be able to use at trial, it's just notes. It doesn't say report on it.
And the pertinent parts say that the defense has to disclose upon the state's, the defense asks for discovery, then the defendant has to comply with reciprocal discovery, which the rule says.
There you go, reciprocal discovery.
Inspect, copy, or photograph any results or reports of physical or mental examinations.
You hid the ball. You better get punished on this one.
That's what all the appellate cases mainly deal with, is insanity, mental health examinations, and of scientific tests or experiments made in connection with a particular case or copies thereof, if the item is within the defendant's possession, custody, or control, or the defendant intends to call as a witness at the trial the person who prepared the report.
Yep.
So, does this
report is not, a titled report that's 20 pages. It's anything that person generated.
Document deal with scientific tests or experiments?
Judge, she's giving her opinion based on the review of the tests.
Right, but did she do any scientific tests or experiments?
Well, I don't know, not that I'm aware of, but she refers to laboratory testing confirmed.
Okay, but then on the second issue, if it should have been disclosed, it didn't exist till this weekend, which this is, what is this, Tuesday? So the state could have gotten it 48 hours earlier. So we get to the bottom line of, if there's a failure to comply with the request, the court may order the party to permit the discovery inspection. It's already untimely for that. Grant a continuance, prohibit the party from introducing the undisclosed evidence, or enter such other order that deems just under the circumstance. So If, I hadn't finished yet. If there is, I'm not sure there's a violation of Rule 16, but if there's a 48-hour violation, what is the state seeking the court to do?
Judge, we're asking that it be excluded, just as we did in our pretrial motions.
Okay, but even fall under Rule 16.
It's your decision.
Did you carry her?
How do I turn over something that I don't know exists? There's an email at 10:53.
Did you carry her?
How do I turn over something that I don't know exists?
How do I respond to something? You didn't let it come out. The question of whether you were told not to turn those over or create those or turn those over, something to that effect. And you blocked that from coming out. And now you're trying to say you didn't know anything. I mean, come on, really? Really? You're going to say that in front of a judge? It's just unbelievable. And you know what she's not saying is Your Honor, your judge.
There's an email at 10:53. So it's not.
This is so disturbing that it's really hard for me to watch stuff like this when I see such a joke of a process. This is supposed to be constitutionally based court rules and procedures, and you can just screw up like this and just get away with stuff and not even address the court properly with proper dignity and respect.
A report. She has done no scientific testing. She has done nothing of the sort. She made notes for herself to prepare to testify. The court tells us, reach out to our people, find out if they have notes. Today is Monday. I'm in the middle of trial, questioning witnesses, trying to get all the experts together.
Yeah, all the witnesses, you said, don't create any reports, because then I got to turn them over to the prosecution. Did you say that at all? That's what I'd be asking as a judge.
To give the court what it asked for. That's difficult to do when I'm directly
All this violin playing in here.
examining and putting on my case in chief. So at the break.
48 hours, then she did it on Saturday, which I don't choose you and ask specifically. Go ahead.
And so we're complying with what the court asked. She did call us and tell us that's what she was doing. And as I
This is just so.
stated, it's not even a scientific test. It's nothing that she conducted any type of test on her own. We don't intend to introduce it into evidence. So I don't understand.
Yeah, handwritten notes. Yeah, I don't think you would. So I don't understand. Yeah, why I can't get away with hiding the ball.
What it is that we don't know.
Okay, anything further?
Judge, I have a secondary objection,
Okay.
depending on if you were going to allow it.
All right.
The state has a couple of other issues with this report, his notes or report, whatever it is. Her report relies on information that is inaccurate and it's not in evidence. And it's specific to that urine test that Ms. Collins keeps attempting to ask all these witnesses about that is not in evidence. And the state is, again, asking that she not be allowed to testify to any of the lab reports that are not in evidence, but she based her opinion on a lab result that is incorrect.
Another hot mess from the defense. What do you expect? Shut it down. Shut it down, Judge. You're allowing this insane circus to continue this whole day.
As to the cause of death, and the state's position is that she's not qualified to do that.
Since she's an ER doctor, where are you referencing a specific date about a urine screen?
So on her handwritten notes, it's kind of sleepy.
Oh, I don't have,
Oh,
who are
I'm
you referencing?
So
Dr. Lindsay?
Dr. Lindsay references that drug sample, and then Dr. Larkin, I believe, also references the urine sample.
Oops, sorry.
And have you
9:22, I think.
Report this morning about 10:30.
No, sorry.
From your deposition you introduced, say there was no defense administered.
Correct, as well
I'm
as,
asking Ms. Holland.
Exactly, so what that means is when that urine test was tested.
What urine test?
The urine test that was tested before she was administered in
By
the
who?
blood test, in the blood test,
Tested by who?
tested by NMS.
no, NMS did not
No,
test that.
They didn't.
It was CFSRE.
That's where the
Since when,
courtroom's full of.
since when does a
confusion.
prosecutor call a lab and be able to change a medical record and we have to adhere to it?
No, I'm just asking you, is there proof
No, there's
that you're
no-
asking your expert to testify about?
Yes, for the last
Proof.
3
Yes, Your Honor. Why is it so hard for her to address the court with proper dignity and respect?
Bring it back in, Dr. Larkin. We'll figure what work order she's given his opinion about.
Really bringing experts up there to try to get other evidence in that's not admissible, backdoor way. The prosecution would ask for notes, would not even know that you're going to get ambushed in front of the jury like that. The judge doesn't even appear mad. It's been disrespected all day long. All these ambush tactics, surprise ambush tactics. It doesn't seem to be bothered by it.
What General Norman is the work order that no one's been here lab-wise to testify about?
NMS 2307
230.
78883.
You gonna be able to testify without anything in front of you?
No, and no.
So my question is anything in this document, 3-page document, that has anything to do with work order 2307883?
I don't know, I think Dr. Yancey's in the back, she,
You're looking at the document that I submitted, not Dr. Larkin.
Why are you standing up?
Because
Just have a seat.
okay, I think, so
Just have a seat.
I don't have any
You
reference
see
to any
the
work
last
orders
two
in there.
sentences in your report?
It's not a report though, right? Yes, I see that.
Where'd you get that information from?
From the toxicology records that I looked at.
From who? What lab?
I would have to look, I can't remember. These are just notes that I have.
How are you gonna testify? What are you gonna use to find that out?
We'll put those up when I put up the notes. I can ask to have that
She's
put up.
thinking about.
Let her testify tomorrow.
So you have no clue where you got that information?
I got them from I have all the toxicology reports and I have summaries. I would have to look exactly where it came from.
Okay.
If this were a report, it would actually have reference to that.
Okay, well, tell me where that information came from.
I would have to have the reports
Do
to
that.
pull it up.
Where is it? Is it the same report you asked about earlier or this
Well, I
one?
can share this with you.
Not gonna shut her
What I plan to testify or have her testify about is
Where is
I'm alleviating your issue. What I-
You're not asking her about those last two
I'm not.
sentences? Oh, you said earlier you were.
No, I didn't.
Yes, sir.
Then why'd you put this in this document?
As she said.
Those are just-
I'm not asking you.
I mean, she just cuts off the judge, doesn't her? This is just such garbage.
Those are just notes for me to
So
look
you
at.
didn't rely on
I've
this?
never
You
actually
didn't rely
produced
on this
something like
last
this.
paragraph for any of your opinion.
How a judge allows this to go on is unbelievable.
Not for what I'm going to be testifying to. No, those are just some of my thoughts I put
Okay,
down.
why don't we do this?
If I-
You ask her what you want her to testify about.
I'm gonna tell you, she's not prepared right now to testify for that because I don't have my things together yet. She's
What
going
do you
to
need to
testify.
have together?
I'm gonna tell you what the two reports that she's gonna testify.
Yeah, you don't have your stuff together. I'll second that. Yeah, that's right. The Curville trying to get inadmissible reports, erroneous dated reports over and over. Yeah, this courtroom's a circus. It's turned into a big circus, a big fracas.
Okay. Give us those.
I don't have any problem with
Sure.
this, sir. 231-26889 is one of them.
He's not a new judge. This guy's been around for a while, and attorneys can get away with this in his courtroom. I mean, you just got to laugh at this, I guess. That's the only thing I can do to try to overcome the disgust. Just laugh it off. Yeah, it's a big joke, right?
And then 231-29285.
Yep. National Town Show here. Oh, Jesus, murder trial? Good point.
Sir, that's the first blood and the comforter.
Okay. You got issues with that?
I do not have issues with that. I do have issues with this witness whose non-report that I consider to be a report relies upon false information. And
I don't know. Let me try to find out again. Your opinion that says the history, witness observations, clinical presentation, toxicology findings, and objective medical evidence support the conclusion that Jade's collapse is more consistent with respiratory arrest resulting from combined cocaine use and pre-hospital fentanyl exposure than with a primary sole cocaine-induced cardiac event. Is that your bottom line?
Yes, sir.
Where do you get
Okay, so there's a dual spike drink.
the information that there was pre-hospital fentanyl exposure?
Clinically, I can tell you in my 30 years of experience in treating patients with different types of overdoses, we have a clinical picture, we have the 911 call, we have the other witnesses that have spoken, we have the EMS.
You're talking about the sleepy, awake, talking, doesn't feel right, that kind of
Yes, and then, and the two reports that we'll be talking about on the comforter.
nothing about the comforter and the report.
So the,
Unfortunately, it wasn't tested for and everything.
what wasn't tested?
She's not privy to it because I haven't had the opportunity to meet with her, which I had planned to do tonight.
What
The
wasn't
state-
tested for?
Not everything
Cutting off the judge again, but who cares?
I wanted to know was not necessarily tested for in,
On what?
in the urine that's no longer done at 225.
But that's what I asked. You said you included your toxicology findings in making that opinion.
Your Honor, what is unfair is she's telling you that those are notes. Those are not her lasting opinions. That is not a report. So you're trying to commit her to something that she never intended to be there.
Yeah, shame on you, Judge. I'm going to call you out on it.
So that's unfair to ask her for that. She has stated as a medical
She's not even addressing the judge as judge or your honor. I do.
professional
She
doctor.
put, why did you include that paragraph?
Those are her notes.
Those are just some of my thoughts. It doesn't mean they were
So
what
this paragraph on the bottom of page 2 means nothing to your opinion.
I'd have to look at it again. I just made some notes and I probably put, I mean, that's not the basis of my opinion, but again, they're just notes. They're nothing official. There's no report. I don't write a report that looks like that. So just was asked to give some notes and they were some things I just put together this weekend. And
I mean, just think about Jade's family there, seeing this kind of utterly. I got to watch what I say here. Utterly disgusting is the nicest way I can say it. Behavior of the defense attorney, and the judge lets her get away with this.
You don't know, Ms.
How disrespectful to the victims.
Collins, that you plan on asking her about any pre-hospital fentanyl use.
Yes, I do, because it was in the vomit. Their own witness testified that the vomit was the fentanyl was in
From
the
the
vomit.
lower level and all that.
It's hard, it's really hard. But what I'm saying is that the
How about addressing me as Your Honor, Judge, Counsel?
Fentanyl was found in the bomb. That was testimony that came from that.
But you don't
state.
plan on asking this witness anything about that other work order?
No, I don't.
Okay. Any other questions?
Yes, Your Honor. The state, number one, that was not Dr. Mithen's testimony. Dr. Mithen was very specific.
Okay, you have questions of this witness?
Yes, this witness's notes include a reference to the EMS guy said he thought it was an allergic reaction. We do not have those facts in this case.
Where are you referencing?
That is the last sentence in the first paragraph. Our EMS witnesses said the exact opposite.
Well, here's what I can't do. And again, if she testifies tomorrow in front of the jury on inaccurate information, then again, have the Perry Mason moment and say, everything you've said is based on inaccuracy, would be inaccurate. But she may not be asked that, so I don't know.
Yeah, you're letting it in.
We'll have to wait and see what she's asked. So from there.
Yeah. No control.
Anything else?
Your Honor, may I ask that Dr. Carney be able to watch her testimony if she testifies tomorrow
Sure.
remotely so that she doesn't have to be down here because she's been here all.
All right, so there you have it. So it's getting away with it all day long, unprepared, trying to slick stuff by, backdoor stuff in, and just I don't know. I don't look at this as a court of law, really. A lot of this kind of stuff. Yeah, it's an absolute mockery. Absolute mockery. Yep. I agree. Texas born. She's just correcting the judge for a reason. She's showing the court that she's in charge. She knows he won't stand up to her. Yeah, you know what? You see that too, Ruthann keeps interrupting the judge. Hear the desperation. Yeah, well, you know what? There's always an equalizer out there. Unbelievable. Well, you know what might happen? All this stuff going on behind the scenes, maybe the jurors are going to be looking at it even though they're not supposed to. So this kind of behavior is not going to win in the end, just as I've said in oops. There's a whole new format here on this StreamYard. I don't even know where stuff's at right now. Hold on. Okay, sorry. So anyway, it's yeah, this is an embarrassment. It's an embarrassment for Tennessee. I don't get it. I don't get it. I don't get it. So in the end, you cannot win cases acting so inappropriate, unprofessional. Okay, you're just not going to win cases being that way. So I'm just going to have confidence in that, and the truth's going to come out, and justice is going to be done. So despite all these shenanigans, and that's a nice way I'm putting it. So anyway, y'all have a good night. It's been going on, over 3.5 hours. So thanks for your search for justice in this case. You cannot imagine this is going on, right? So the way the courtroom's being handled is actually even more bizarre coming to life than the actual murder itself, because you just scratch your head thinking, how can this be going on over and over again? So anyway, all right, signing off. Have a good night, and hope to see you back tomorrow night. Take care. Thanks.